Again, order to mention. Mention, my lord, against the order of Lord Odisha Administrative Tribunal. It's a case of 2017. Against the sanction post, the petitioner was appointed, but his post has not yet been approved. Here, my lord, once the honorable court has directed the BEO to obtain an instruction since a year also, it has not come. Obliged. CRL 1918. Mother matter CRL 117 to 22. They don't list.
For what purpose you mean?
Bail. One is bail, another is
Criminal appeal for bail matter. Another jail criminal appeal for bail. Okay.
I take a lots of the bottom a lot of mentioning item number 29, the tender matter. That tender matter, which your lordship was hearing, day before yesterday, my lord, it was there. It has come in item number 29. May I pray, my lord, this matter to be taken up?
Just intimate the others.
My lord, I have already intimated, my lord, your lordship had also that.
The moment they come, we can.
My lord, duplicates.
Yeah.
So appeal with DCR 1822.
For what purpose you are mentioning?
Yes.
For what purpose you are mentioning is to be listed?
Bail appeal.
Bail, give it.
My lord, there was a description in the order dated 4/7/2025, my lord. The petitioner name has been wrongly mentioned.
Give it. You should, he has filed a memo. He has not signed the memo. Ask him to sign the memo. He keep that order with you and give that memo in the proper format. There is a memo format, not that in this manner you should give. Just mention it if you have filed any interim application for correction of the cost title or the date of order, whatever it may be. File it appropriately, giving that number so that it will be listed. Otherwise, it cannot be listed. Have you filed any application for correction? Then how can it be listed? Why it will be listed?
Disposed of matter can't be listed unless you move an application.
If you want any correction, suppose date has not been mentioned or the party name has not been, so given an interim application for correction of that so that it can be listed. All right, keep that with you. Yeah.
Item 20, praying for an adjournment.
We will see that also.
One appeal from them. One appeal from them.
You.
Supplemental list, item number 1.
The last occasion, lordship directed them to produce the charge sheet. I have already given the charge sheet last date, but this is a matter against the order of London Central Administrative Tribunal. But I was invoking power under Article 311(2)(c). In the name of the President, Honorable President, the Additional Secretary has passed the order dismissing me from the service. Since there is no further provision either to file appeal or revision, directly I approach to the Learned Tribunal. Before the Learned Tribunal, the department has, it was also the specific stand of the department. If your lordship will come to the page 67, that order starts, Learned Tribunal's order starts from page 63.
Have you filed a copy of the charge sheet and the documents relating?
Yes,
to the
my
status of the
last
case?
occasion I have given that copy.
What is that?
That I have already. Survey copy, my lord.
What is that document?
वो चारी कॉपी करके अंतिम दीटा कॉपी
No.
already
So, right,
submitted.
if you have filed before the registry,
Yeah.
that has not been tagged to the file at least.
But
Is
if you
it-
lost it, if you lost it,
No.
the original is with me. If you lost it,
Is it available? You say that as per the
It's
order
within-
dated 15/4/25, he has filed the copy of the charge sheet and also the documents relating to the status of the case, mean the order sheet of that case. So it is not there here. This is supplementary affidavit is there, that's all. Is it there? When you file that? The date and why have you not given the copy also to the land council?
My lord, 27/3/2025, my lord.
No, that order was passed in April and you are, the noting is
Not filed.
supplementary by petitioner as per order dated so and so not received from the land and council. That order was passed on 15/4.
Yeah.
So how do you file on March 25?
Lord, you'll also kindly keep this matter to some of the, I have the copy, Lord, certified copy also.
File କରନ୍ତୁ ଆପଣ ଆପଣଙ୍କ ପାଖରେ ଥିଲେ କଣ ତାଙ୍କୁ କପିଟି ଦିଅନ୍ତୁ।
We have asked it because the charges are very serious.
Serving a copy to him and to two other copies I filed.
The land and council for the petitioner submitted that some more time may be granted to file the copy of the charge sheet in the case which was instituted against the petitioner. So also to the documents relating to the status of the case, said case, as per the order dated 15/4/2025. Put up this matter, you want next week? No?
Next week.
Put up this matter next week. The copy of the documents we also handed over to the land council.
I have
for the
already handed out.
division.
Yes, they
Has
will.
already been handed over to the land council for the union of India.
Obliged.
Item 2,
This is an appeal filed against the order of the Honorable Single Judge, wherein the conspicuous, the matter was that there were two divisions. That one was International Airport Authority Division, another was Domestic National Airport Authority. Both these branches were merged by an act of the Parliament, Your Lordship. And in both these erstwhile National Airport Authority and International Airport Authority, there used to exist one cadre called housekeeping cadre. Under the International Airport Authority, from which I come and people like me come, they were posted with better qualification at a better level with 4 promotional avenues. In the National Airport Authority Division, the qualification was less, and the appointment grade was less, and they didn't have any promotional avenues. However, by this merger, both these cadres were merged to form a single cadre. And in that single cadre, a common gradation list was prepared, and this housekeeping cadre was permanently abolished. It was merged with terminal management, and a fresh gradation list was prepared by the intervention of a retired Supreme Court judge. So, in that gradation list, people who came from International Airport Authority with better qualification and at a better entry level, they were placed higher in the gradation list, and they were to be given promotion at a particular date in time once they achieve the eligibility for that promotion. Those who came from National Airport Authority, they were placed below us in the common gradation list. However, the opposite parties gave promotion to those who came from the National Airport Authority division, ignoring we who were placed higher in the gradation list. When we complained, the HR manager of Airport Authority of India issues an order that the merger is cancelled. The fact of the matter is that the merger was by an act of the Parliament. And here the HR manager writes that the merger is cancelled and produces separate gradation list, says that merger is cancelled. That was the case on which this writ petition was filed. Honorable Single Judge has not, has unfortunately failed to appreciate the facts adequately to the extent that he has invoked 4 judgments to dismiss the writ petition. However, if the facts and the rules had been correctly appreciated, those exact 4 judgments could have been invoked to grant the writ petition, Your Lordship.
Let us see the reasoning.
And I have discussed the impugned order paragraph by paragraph. My lords, permit the
Which is that act you say that by which that merger took place and
Airport Authority of India Act, Your Lordship.
which provision that says that?
I'm extremely sorry, I asked for the book, but I just forget it. Okay, Airport Authority of India.
We'll get it from next week. As prayed for by the Land Council for the appellant, place this matter next week.
Item 3.
Already filed the affidavit in para 3. I mentioned I recollect 3 more times to sell the land and repay the outstanding loan through the what is
Just a minute.
Where is the affidavit?
Last stretch. Thirteen 4 notice has been issued on 18/4/2024. Then what has happened?
the position all taken away. So already threatened to dispose me of my house.
So how can we interfere at this way? Go and approach the before the. Have you stated all those things in your petition? That possession has been taken and you have been all those things. Where have you stated? You have only stated that I am ready to pay. It is ready to pay. You should have at the appropriate stage. You would have approached the bank or the forum when that 13/4 notice was issued.
Constable, I'm the poor man. I am ready to
Sorry,
pay.
you cannot entertain at this stage when, but fact remains that you have suppressed all those things. So now the property has been handed over to whom?
Property not handed over.
Then?
Property, I am in possession.
No. You might be in possession in the, but the order must have been passed that after that auction must have been successful in the meantime.
No, auction.
Then?
Auction, I'm not taken. No.
अरे कौन स्टेजटा कुहतु 13/4 नोटिसटा पर आपण लिखिछन्ती एफिडेविट रे जे 13/4 नोटिसटा हला 18/4/2024 come to your paragraph number 5 of the affidavit. So thereafter the usual process that takes place that must have been taken place, and what is this status now? What is the
only threatened to me to dispose this with help of police.
where is that 13/4 notice?
Since to 34 notice, nothing has happened.
No, that is this. Now, once we issue notice means it is against the order of the Honorable Supreme Court. They say that alternative forum is available, go there, and you approach that. That's I like. This petition has been filed by the petitioner Madan Mohan Malik with a prayer for a direction to the opposite party to settle his loan account number so and so prayer personal লেখাইছি to one time settlement bracket OTS without evicting the petitioner and his family members from the mortgage property, that is the residential building standing over plot number 258, Khata number so and so লেখাই prayer also. When a submission was made by the learned counsel for the petitioner, that the petitioner is ready and willing to pay the outstanding dues of the opposite parties bank within a specific period. And submitted that you file an affidavit in that respect. We adjourn the matter to today, and the land counsel for the petitioner has filed an affidavit wherein in paragraph number 4, 5, and 6, it is mentioned as follows, quote paragraph 4, 5, 6. From the said affidavit, also from annexure 1, it appears that position notice under section 84 of the Surface Act has already been issued on 8/8/2024. Therefore, in view of the law laid down by the Honorable Supreme Court in case also, alternative remedies are available. The petitioner can seek appropriate remedy in accordance with law, or approach the bank. We have not expressed any opinion. Accordingly, the petition is disposed of. Bank for settlement of the loan account. Yes.
Item 4.
Yeah, please. So by filing this petition, the petitioner has challenged the order of dismissal dated 20th January 2025, passed by the London CIT Court of Bench in OA number 479 of 2019.
You are supposed to file that original application.
My lord, I have already filed. That is a notice that I have.
Yes, it is not of.
I have soft copy. And I have.
Uh,
Matter relates to stepping of pay, my lord. Admittedly, this petitioner,
You are challenging the order 21/2025.
mine,
That is annexure 36.
36,
Okay, come to that order first, we'll hear you.
mine.
So in the first paragraph, your prayer has been quoted. Just read it that time. Page number 122.
Mine.
Yeah.
Seeking a direction to respondents to step up his pay with effect on 21/4/2006 at par with one SP Naik, Respondent 3, who was working at PS in Eco Railway and paid difference area salary.
Now come to the operative part.
Mine.
Paragraph 6.
Mine. We have considered the matter in its entirety with reference to the pleadings.
Para 5.
Clarified.
Mine. It is the case of applicant that, as per terms and conditions, the Respondent 3 deployment to East Coast Railway after bifurcation ought to have been made in his substantive post and not as a CA, in which post he was continuing on ad hoc basis, whereas the respondent's department intentionally shown him to have been posted and allowed to continue in the railway as a CA on ad hoc basis only to favor him, adhere the rules. Hence, according to the applicant, since he is senior to Respondent 3, in no circumstance he could have been allowed to draw higher pay than him. We have considered the matter in its entirety with reference to the pleadings, arguments, and documents filed by the parties concerned. It is not the prayer of the applicant that the ad hoc promotion of the applicant to CA earlier than him was in any way not legally tenable and is liable to bequest. The sole prayer of the applicant that this way for stepping of his pay at par with Respondent 3. Admittedly, Respondent 3 was promoted to the post of CA on ad hoc basis in scale of rupees 1,640 to 2,660 on 9/7/93, followed by regularization on 21st April 2006, to which post the applicant was also promoted on 21st April 2006. The Respondent 3 admittedly was deployed in East Coast Railway while he was continuing as CA on ad hoc basis since 9/7/1993 in pay scale of rupees 5,000 to 5,500 to 9,000, whereas the applicant was deployed in East Coast Railway while he was continuing as senior stenographer. Full stop. Therefore, the pay on their regular promotion to CA was rightly fixed, taking into consideration their pay scale, which they are drawing at the relevant point of time, and admittedly, the Respondent 3 was drawing higher pay than the applicant. Full stop. Therefore, the stand of applicant that since the pay of Respondent 3 was fixed at a higher rate, his pay should be stepped up at par with him is a fallacious and misconceived argument having no leg to stand.
You have not questioned her,
My lord,
Respondent Note 3's promotion.
your lordship may kindly come to para 4 of that judgment order, my lord. Before the tribunal, there was a pleading. Applying a RB number, they have taken the decision. I want to place that RB para B, my lord.
Answer whether you have challenged the promotion of Respondent Note 3.
My lord,
If you have not challenged, that has been attained finality, regularization has been done.
My lord, Respondent number 3 was given ad hoc promotion, my lord, not regular promotion. All regular promotion I have granted first, my lord. In all cadres, my lord. Senior stenographer, CA and private secretary grade 1. In all the three senior list, I am above than the opposite party number 3, my lord. They are relying upon one memorandum, but my submission before my lord is that that memorandum is in my favor, my lord. As because at no point of time I have ever denied for any ad hoc promotion, my lord.
No, he was working as ad hoc CA from 9/7/1993 and regularly promoted in 21/4/2006. And you also got promoted as well. So the earlier ad hoc period has to be taken into consideration. In the absence of your challenge to the
Your lordship only give a glance that OM, then my lord. OM, my lord, which they have relied upon in the counter, my lord.
Let us see the prayer of come to the prayer portion.
That is only prayer, not challenge you.
Not challenge. That's the problem with you.
Because my lord, he was working in a different place. We belong to one cadre under SC Railway, my lord, having jurisdiction 4 states, my lord. So when it comes to my knowledge that he has given, I make a representation. I ask for stepping of my pay since 2006, my lord. All my representation taken into consideration, not finally acted upon, my lord. They have admitted that I have made representations to grant me ad hoc promotion, as because at no point of time either I was a deputation or on leave or any punishment imposed on me. Being a senior man, it was my right for consideration. You have not considered the same, man.
So that happened in 1993.
So it
That
comes
ad hoc promotion thing has happened in 1993.
so my lord, it comes to my knowledge in the year 2006, my lord.
This thing.
So I have made an application seeking condonation of delay. My application allowed, delay condoned, my lord, by the Lord Tribunal.
Have you questioned the ad hoc promotion given to him in 93?
Lots of the matter.
Have you questioned? You have not questioned. He was ad hocly promoted in 1993. He continued till 2021. And you also got promoted in 2021. Today you moved in OA and saying that you step up my salary above him because I was promoted in the same day.
So because my lord, until I am a senior man, my lord.
That's the problem here.
My lord, I have relied upon one judgment of honor appeals. If it is in my favor, you lordship kindly give glance. Para 19 and 20. para 17 and 18. Placing para 17. Something may be said with regard to Mr. Sabra's submission about the difference in increment in the scales in which appellant 1 and Sri Sohri are placed. But the same is still contrary to a settled principle of law, and that a senior cannot be paid a less salary than his junior. In such circumstances, even if there was a difference in the incremental benefit in the scale given to appellant number 1 and the scale given to Sri Sori, such anomaly should not have been allowed to continue and ought to have been rectified so that the pay of appellant 1 was to be stepped up to that of Sri Sori, as appears to have been done in case of appellant number 2. We have unable to accept the reasoning of the High Court in this regard or the submission made in support thereof by Mr. Sabra, since the very object to be achieved is to bring the pay scale of appellant on a par with that of his junior. We are clearly of the opinion that reasoning of High Court was erroneous and appellant 1 was also entitled the same benefit of pay parity with his
But you are getting at par. You are getting at par, but you want to step it up.
That is the
I
problem.
am not getting par mile. I am claiming equal pay at par with my junior mile. Because he admittedly was drawing higher pay than me, being a junior.
The reason which is, or the factual scenario in this case was not there in that judgment. That is the basic difference between the
In this
citation.
case,
which-
my lord, admittedly, I am a senior one. I was drawing lesser pay than the.
He was
And
promoted.
a
at the-
recently a judgment delivered by on the appeal court. If lordship has take up this matter next week, I can place that judgment also in my favor. In all respect, in all grades, my lord, I am a senior. I got promotion much earlier than my junior man.
So this finding which has been given by the learned tribunal, that admittedly respondent number 3 was promoted to the post of CA on ad hoc basis of so and so in 1993. Whether it is a factual, is there
But-
any incorrectness in that?
For first time, they have replied in my counter. Though
No, no.
So
You have not questioned that.
my lord.
No knowledge re nathila,
So I have replied the same in my filing rejoinder. I have relied
I
upon
was
OA.
holding a promotional post since 1993 and maybe on ad hoc basis, and regular promotion was given in 2006. That is how you are not challenging that day. Now you are.
And while drafting the OA, tactfully you have done it because you know that this problem will come. 93 thing you will challenge it in
I am claiming
2000.
pay parity, my lord. Because department allowed me to draw less pay than my junior man. And more particularly, the same came to my knowledge when we both
So
joined
the
in.
question is, if junior who has been promoted earlier to you,
Not regularly, man. Not regularly. Being a senior, I got a regular promotion earlier than my junior man.
you have some judgment, so if you can cover.
Let me call this matter. 1 week after, I can.
Even if he's promoted before you, you are entitled to.
Man.
As for the order dated 14/7/2025, the counsel for the petitioner has filed the copy of the original application, which was filed before the Central Administrative Tribunal, so also the counter affidavit. Stop. In this writ petition, the petitioner Pramod Panda has challenged the order dated 21/2025 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number 479 of 2019, with a further prayer for a direction to the opposite parties number 1 and 2 to step up the pay with effect from 21/4/2006 at par with opposite party number 3 and to reduce the consequential financial benefit. It appears from the original application that the petitioner filed the said application for a direction to the opposite parties number 1 and 2 with the following prayers. Quote from that evaluator recently filed question the way relief sought for paragraph number 8 A and B लिखा है जिसे दिया कोट कर दिया. The learning tribunal, taking into account the submission made by the learning counsel for the petitioner, so also the counsel for the opposite parties, came to hold that the opposite party number 3 was promoted to the post of CA on ad hoc basis in scale of 1640-2660 on 9/7/93, followed by a regular promotion on 21/4/2006, to which post the petitioner was also promoted on 21/4/2006. The opposite party number 3 was deployed to East Coast Railways while he was continuing as CA on ad hoc basis since 9/7/1993, whereas the petitioner was deployed to the East Coast Railways while he was continuing as senior stenographer. And accordingly, the learning tribunal observed that the pay on their regular promotion to CA was rightly fixed, taking into consideration their pay scale, which they were drawing at the relevant point of time. And admittedly, the opposite party number 3 was drawing higher pay than the petitioner.
It was filed on 14/7/2019.
Therefore, the stand of the petitioner that since the pay scale of the opposite party number 3 was fixed at higher rates, his pay should be stepped up at par with him is a fallacious misconcept. Accordingly, the OA was rejected.
The OA was filed
The
belatedly.
learning counsel for the petitioner fairly submitted that when the opposite party number 3 was promoted to the post of CA on 9/7/1993, there was no challenge made to such promotion by the petitioner. And even in the original application number such and such, which was filed on 14/7/2019, also there was no challenge to the such promotion which took place in the year 1993. Learned counsel for the subparagraph petitioner placed the citation in the case of Guru Charan Singh Grewal and another versus Punjab State Electricity Board and others, reported in 2009, (1) Supreme Court cases LS 578, wherein in paragraph number 17 and 18, it is quoted, it is stated as follows, quote paragraph number 17 and 18. However, after going through the factual aspect, we find that the factual scenario in the present case is different than the case of Gurcharan Singh Grewal. Supra. At this stage, the land council for the petitioner submits that the matter may be taken up next week so that he will cite some citations of the Honorable Supreme Court, which covers the issue involved in this case. Put up this matter in the week commencing from 21st July 2025.
You would also explain, after 13 years you have approached the tribunal, 2006 the promotion, and 2019 you are coming to the court for the first time.
To that, my lord, I have filed MA. My MA is allowed by the Lord Tribunal. Checking
That's a different story, but you have to explain the bill.
That order also I have.
We'll see.
Next.
appearance will be noted.
Acha,
Kiri.
Mr. Pari
Certainly.
and
Along with Mr. J. Ponda is appearing.
Mr. J. Panda. Central Government Council, no?
My lord, please.
Yes.
Item 5,
My lordship. Lordship,
Yes.
one I filed for amendment, lordship. Amendment for the authorized officer name may be deleted and after the word of the
Let us come to that IA. So,
Schedule of amendment is that
first and
Phase two.
second line of the first title font show the name of font. Authorized officer. Okay, no, any objection?
formal.
All right. IA number one, so there is an application for amendment. After going to the amendment petition and the nature of amendment sought for, and since the land council for the state has no objection to the same, we are inclined to allow the prayer made in the interim application, and accordingly, the schedule of amendment now shall form the part of the petition. Land council for the petitioner shall file a consolidated. You are ready with that?
Lord.
File the consolidated first title, which is taken on the, give a copy to the. So we'll take up today or some other day.
lordship to that.
Acha, just let it come, regularize set up scanning again for ASU. We'll take it up on Friday, right?
Lordship.
This matter on 18th of July 2020. Yeah. But is it on the physical file available?
item 6,
Please, Lordship. Order of London Central Tribunal Court of Bench under challenge. Annexer.
Yes, Mr.
Yes, no. Petitioner has challenged the order of London Central Tribunal Court of Bench at Annexer 8, my lord. Page 45.
You have filed that original
Yes,
application?
my lord.
When?
On 3rd July.
Okay, that is there.
And
And
routine
even
is there,
now-
my lord.
Yes. So which order you are challenging?
Order of London Tribunal, Central Tribunal Court of Bench, my lord, by Annexer 8, page 45. My read petition.
17/4/25. Annexure 8, right?
17/4/25, my lord. Annexer 8.
You come to the first paragraph, there your release sought for has been mentioned,
Page 46.
right?
Yes.
Please place it and then go to the operative part.
Yes,
where
ma'am.
we discuss.
A, to quash the order dated 3/5/2018, Annexure A by 6, passed by the respondent number 2 holding the same is against the scheme formulated by the government. B, to pass appropriate order directing the departmental respondent to grant selection scale from 9/11/2001 instead of 1/1/2007. like others and grant him all consequential benefits by revising the pension and pensionary benefit with appropriate interest on all area due retrospectively. To pass any other two pair is main matter. Thereafter,
What has been held by the.
that is at page 51, para 9.
Para 9.
Read it.
As seen from Annex A by 3, the applicant was not granted selection scale because he had not attended in-service training course in the preceding 6 years. In the said letter, it is seen that around 44 employees were granted the selection scale, but all of them were senior to the applicant. Further, there are 12 who are granted selection scale with effect from 1/1/2004, 1/1/2005, and 1/1/2006. All joined the respondent organization before the applicant who had joined on 9/11/1977. There are 5 who had joined before the applicant in the year 1977 who have also been granted selection scale with effect from 1/1/2007. The applicant has also been granted selection scale with effect from 1/1/2000. Therefore, there is no discrimination on the part of the respondent in not granting him the selection scale with effect from 1/1/2007. And none of his juniors have been granted selection scale before him. On the condition of granting selection scale is 20% vacancy. The same was not available, hence the applicant was not eligible with effect from 1/1/2001. That is the wrongly typed. Therefore, we do not find any illegality on the part of the respondent in not granting applicant selection scale with effect from 1/1/2000.
Yes.
Case of the petitioner is that, my lord. Petitioner is a retired PGT in PHE. Was initially joined in his service on 9/11/1977. By the Annexure 1, page 16, my lord. I have filed the typed copy, my lord.
No, you have filed the date chart, we are looking at it. So.
Yes, my lord. Well, Annexure 1 will be convenient, my lord. That is the circular by the HRD Department of Government of India, my lord. At page 17, bottom of the page, my lord, clause I. The revised pay scale will be admissible subject to the following conditions, my lord. While senior scale will be granted after 12 years to primary school teachers, trained graduate teachers, headmasters of primary school, and postgraduate teachers, the selection scale will be granted after 12 years service in the senior scale, my lord. That means, my lord, 12 years in senior scale, thereafter, after completion of 12 years, the selection scale, my lord. In page 18, clause IB, some conditions has been imposed, my lord. Every teacher, page 18, my lord, clause IB. Every teacher would be required to participate in an in-service training program of at least 3 weeks duration before he or she cross an EB or is promoted to senior scale on selection scale. That is once in every 6 years, provided that where arrangement for such training cannot be made, the appointing authority may exempt a category of teachers for specific period of time, my lord. This is the condition, my lord. Basing upon this circular, by Annexure 2, I have been granted senior scale of payment. That Annexure 2 start from 20. I am at page 21. Clause D, miscellaneous category.
The concluding paragraph, which is at paragraph number 9. What is the perversity in that? It is that the persons who got that selection scale, that they were all senior to you.
Yes, ma'am. I am coming to that point, ma'am.
Yeah. And the persons who are similarly situated, all of them got it. They were granted selection.
My lord's query is at page 37, Annexure 7 series, ma'am.
Yeah.
Your lordship kindly had a plan. In which order they have granted me selection scale of pay from 1/1/2007.
Right.
That is
discrimination you are raising.
Yes, my lord.
Why is the discrimination?
Discrimination is page 37, bottom of the box, my lord, serial 1.
37, bottom 1.
Page 37, Annexure 7 series, my lord, my writ petition. Serial 1, Sri Ram Milan Mishra, TGT Hindi. Initial appointment was 23/9/1982, my lord. My appointment is 9/11/1977, my lord. He was granted senior scale of pay on 23/9/1994, my lord. I was granted selection pay in 1989, my lord. 77 after 20 years, that is 9/11/1989. Thereafter, he has been granted selection scale of pay on 23/9/2006, my lord. I was granted on 1/1/2006, 7, my lord. He is junior to me, my lord. He has been granted.
No.
I immediate after completion of 24
No,
years, he has got the selection scale.
This 23/9/2006, if he has got it, it is earlier to you.
Yes, my lord.
So when you challenge that matter? Have you challenged it?
Yes, my lord. This order was passed on 3/5/2018, my lord. After my retirement, much after my retirement. I was retired in the
Now
month of
your 2006 matter, you are challenging it in 2018.
no, my lord.
Are
My lord.
ଆପଣ place କରୁଛନ୍ତି ବର୍ତ୍ତମାନ just
Yes,
now you
my lord.
placed it.
That is the discriminatory. My lord.
But it should be challenged at a particular time or
Yes, my lord.
whim and pleasure after the retirement you will
I
challenge
was
somebody's promotion to a particular
lord.
post which took place much before.
My lord, I was retired on 31/5/2012 from the service.
Yeah.
Thereafter, one DPC was held on 6/6/2012. That is
Para 9,
that
para 9, the annexure which is referred to A by 3, the same one which you have read out at page 37.
yes, my lord.
Same.
Yes.
And it has been explained by the tribunal. If the
Yes,
same,
my lord. I have already filed.
1 minute, the same annexure
Yes.
which you are saying that it is the junior is promoted. To that effect, in para 9, it is explained that those people are the people, those who have undergone the training for 45 days, which you have not gone.
Yes.
Undergone. Therefore, they were given. That's what the reasoning is.
Yes, my lord. Before him, I have undergone departmental promotional course, my lord, deputed by the department. Before him, that is at annexure 3 series, my lord.
The name which you read in that para 37, he falls under that 12% who have been granted the selection grade from 1/1/2022. No, he was given in, yes, he's one of them.
Yes, my lord.
He's one of them,
Yes.
isn't he? One of them. You say that you have got the training prior to him.
Yes, my lord.
Where is that?
Where is that?
Well, that is annexure 3 series, my lord. Page
Then there is an apparent error, maybe.
Yes, page 22 to 24.
22 to
24.
where is the training?
From 10th December to 10th December 1994 to 13th December 94. First training course I have completed as deputed by the department. Thereafter, from 30th May to 19th June 2003. Third course I have completed on 12th to 1st February 2010. Petitioner cannot go, my lord, for departmental course unless until the department will opted for. When they deputed me, I have gone for promotional course. I never deny me. All the things I have raised before the learned tribunal, my lord. My pleadings are
Much
there. After my retirement, my lord,
Government is
annexure 4 is the DPC order, my lord, at para 25, page 25, my lord. Page 25.
If you are making out a case of apparent error on the face of record, then you have to file a review.
No, my lord.
That's what you are saying.
I have been denied at page 29 on the ground that I have not completed.
But you have completed. That's what you are saying.
Yes, my lord.
So then, therefore, you go and tell the tribunal that wrongly you have mentioned that I have not undertaken the training. I have undertaken the training. That's the apparent error on the face of record.
They have rejected
Where is the question of read petition now?
They have rejected my application on the ground that no junior have been given, my lord. All the documents I have filed before the Learned Tribunal, my lord. My pleadings are there, my lord. I have filed. Lordship, my lord.
That's right. Oh, then
By Annexure 5, my lord, there is also a circular by the Government of India.
Oh, sure.
My lord, Annexure 5, page 32, my lord. Your lordship, kindly have a glance, my lord. Clause 2. In any particular case, it has been established by the competent authority that attending of in-service course when deputed prior to the due date was beyond the control of individual concerned, he or she may be allowed senior selection scale from the due date that 2 after completion of 3 weeks training, my lord. This is the clear direction. Violating this direction, DPC has been rejected my name, my lord, in 2012, my lord.
So 2012, it was rejected.
Yes, my lord.
When you challenged it?
I have challenged, immediate after that, I have challenged before the Learned Tribunal.
When?
That was disposed on 30th January 2014, my lord. Why?
Where is that order?
That is Annexure 6, my lord.
What order was passed?
To consider my case. Para 3, page 35, my lord. Respondent to consider the reprehension dated 6/9/2012 if the same is received and is still pending with him and communicate the result thereof in a well-reasoned order to the applicant.
What happened then?
Thereafter, they passed the order at Annexure 7 series 3/5/2018. They have granted me selection scale of pay from 1/1/2007.
And the region has been assigned.
Yes, my lord. Region has been assigned. Grant of selection scale after the due date due to 20%
And the
limit.
tribunal find no fault in that reasoning.
My lord,
because there was no vacancy, 20% vacancies.
my humble submission before my lord is, when my junior come to the 20% limit, why not I? My lord, that Ram Milan Mishra is junior to me, 5 years junior to me. He got the selection scale immediate after completion of 24 years, my lord. I am eligible for selection scale of pay from 9/11/2001, my lord. They have granted me from 1/1/2007, my lord. If my junior come to 20% ceiling, my lord, before me, then why not I? This is the sole question.
Has been filed by the petitioner Prasanna Kumar Mangaraj with a prayer to was the order dated 17/4/2025 passed by the Central Administrative Tribunal, Patagin, Point number 652 of 2021. Also, the order dated 3/5/2018 passed by the opposite party number 2. This is room 2 major, it will The further prayer has been made for a direction to the opposite party to grant selection scale of pay to the petitioner from 9/11/2001 instead of 1/1/2007. Like the juniors, and to grant him all consequential service benefits by revising the pension and pensionary benefits with appropriate interest on all the area dues retrospectively within a scheduled time. The Land Council for the petitioner placed the informed order dated 17/4/2025, particularly paragraph number 9, wherein the discussion has been made as to why there was no illegality on the part of the opposite party in not granting the petitioner scale of pay with effect from 1/1/2001.
1/1 that is wrongly typed.
That can be about
That is 9/11/2001.
1/1/2001, which according to the petitioner should be 9/1/2001. Stop. The Land Council pointed out the order dated 3/5/2018 under Annexure 7 series and submitted that Ram Milan Mishra was a trained graduate teacher, was appointed on 23/9/1982. Victor,
My lord.
whereas the petitioner was appointed
9/11/1977.
as a on 9/11/1977. Stop. The said Ram Milan Mishra, এটা কোন তারপর ডেটটা কোন সেটা 23/9/1994
That is senior scale of pay after completion of 12 years of service.
got the senior scale of pay on 23/9/1994. এই page annexure 7 को आसुंदी page 37.
My lord.
We want this on লেখা আছে শিক্ষক হিন্দিতে লেখা আছে
Huh.
so what is this date 23/9/94?
That is senior scale of pay, my
I
lord.
got the senior scale of pay on 23/9/1994 after completion of
12 years of
and the petitioner got the same on
9/11/1989.
9/11/1989 and the state Ram Milan Mishra the last time on the na chani betan man
Chaynik betan nama. Selection scale of
selection scale of pay on 23/9/2006, whereas the petitioner was allowed the
selection
scale of pay kebet
1/1/2007.
1/1/2007. It is the contention of the Land Council for the petitioner that Ram Milan Mishra, being the junior to the petitioner, was given the what do you say that
Selection
scale of pay much earlier to the petitioner, which was illegal and and when it came to the knowledge of the petitioner, you approach the first time kebe you order pehla
Yes, my lord.
Annexure 6.
Annexure 6. When it came to the knowledge of the petitioner approached the London Tribunal in OA number 970/2013.
13, which was disposed of on 31st January 2014.
In which he claimed the selection scale from 9/11/2001 as per rule, and consequently the arrears on retirement, EA packing allowance, revision of pension and pensionary benefits, etc. And the said OA was disposed of on 31/1/2014. And the opposite parties were asked to consider the representation filed by the petitioner dated 6/9/2012
Yes, my lord.
By a well-reasoned order and communicate the same to the petitioner. And since the representation was rejected, the petitioner approached the Learned Tribunal. He further argued that
Well, not rejected, my lord.
mhm,
My representation was not rejected, my lord.
It was
then
given from 1/1
Yes, my lord.
2001.
They have granted me selection scale of pay.
Acha, the
1/1/2007.
the selection scale of pay was granted from 1/1/2007, which was challenged before the Learned Tribunal. The Learned Counsel for the petitioner urged that the Learned Tribunal aid in rejecting the prayer of the petitioner in not granting him the relief sought for, and to grant selection scale from 9/11/2001 instead of 1/1/2007. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Land Counsel for the Mr. Pari, you will appear for all the opposite parties.
Mr. S.K. Tripathi. Hrishikesh Tripathi is usually appearing for
You Kendriya Vidyalaya.
Central School, my lord.
Acha, it is stated that Mr. Hrishikesh Tripathi usually appears for the opposite parties. Let a copy of the copies of the petition be served on Mr. Tripathi. Put up this matter after 4 weeks. Yes.
Public.
Maybe part of my lord. Yes, appeared and Mr. Mahapatra is also there.
I'm present, my lord. I'm virtual mode, I'm sorry.
What is the other counsel?
Is there?
My lord, I'm in virtual.
Which item that is?
Item 29.
Lordship had posed only one question, whether he had the contract or he doesn't have any contract.
I was take instructions on the document which my learned senior had submitted on the last occasion, Lord, sir. Contract document. We have submitted two documents. That contract document was submitted, my lords, as part of the tender form. But the fact remains that along with those contract documents, the 2018 work order and the 2022 work order, which is also a rate contract, that was also submitted, which has nowhere been disputed, neither in the counter affidavit, nor in the reply affidavit, nor in the two rejection orders which have been passed, my lords.
The bunch which was supplied the other day,
My lord.
whether the same setup document is supplied or not?
Yes, that we submitted.
Same set.
Same
Nothing more, nothing less.
No, my lords, nothing more, nothing less.
Then
My lords, the fact is that
Contract he has not submitted. Let him show before this honorable court that 23-24
The bunch
contract.
was given to us.
My lords.
We have seen
My lords.
the 3 consecutive years. First 2 years you have given the contract and invoice and all.
My
And
lords.
the last years you have not given the contract, only invoice.
Let him show before this honorable court.
That is
at
the
least.
ground of rejection of your tender.
That is, if your lordship may permit me, my lords.
He wants this court to infer. He wants this court to infer that he had a contract.
No, sir, two rejection orders.
The expert body has already done it.
No, my lords, there are actually.
and you know the scope of interference in
My lord.
tender matters.
My lords.
At this stage, what is the? We are writing that you have failed to submit. Even Mr. Tripathi also said that you give us now also. Let us see that you have given
That is
that you
exactly-
had a contract of that year, financial year 2023-24. That also you are failing to do.
My
That is what
humble submission is what my learned friend tries to impress upon this honorable court is, Lordship may kindly infer that I am having a contract.
Because of those invoices.
Those invoices.
Because of the invoices.
And a letter which was of
There is a letter
2018.
which I am yet to show this honorable court. Bring to the
They don't like you, they don't want to give you.
No, my lords.
Put an end to it now.
Unless there's one letter, your lordships may kindly see. It is not on the basis of the invoices that I am saying that I be given the contract. Just one.
Let the war go on and say state medical corporation.
Try next year.
Next year.
Next year will be difficult because of this matter, because I have not had any transactions for this financial year, my lords. The 2023-24 transaction is there, my lords. There is one letter, your lordship. I request your lordship to kindly see. Whatever my lords decide, I will respectfully bow down to that.
No, this is a simple thing that
My lord, my lord.
where if for a particular reason it has been rejected, and we said, given you opportunity to produce that particular document, you have failed to. So what is the question of now?
May I just bring to your lordship's notice page 48, my lords.
48.
Because on the last occasion, your lordship's was,
Okay, we will see. So as 48.
my lords.
Okay.
That is a continuation of page 50, the work or the contract which was issued in 2018. That is the main letter, my lords. Dated 17/5/2022, page 48, my lords.
What does it show?
It says, my lords, I invite your attention to the subject and references cited, by reference so and so cited. It was requested to increase supply rate of non-woven bags due to hike in raw material cost to the extent of 39% and also non-enhancement of non-woven bags since 4 years. That is the point that I was trying to put forth before my lords on the last occasion. My lords, this is a continuing contract. The
Yeah.
first letter was
No,
2018.
then in the second, the first year you entered into contract. You had a contract document.
My lords.
Second year you had a contract document. But third year there is no contract document.
This is the contract documents.
He said
Because
no.
but my lord, this is the work order which is continuing, and that is those are the invoices which I have attached to lord.
This
I have done
2022 letter.
because my learned
2022
senior also on the last occasion showed the 2020.
You may be correct, but
invoices.
technically you are stuck. You may be correct. We accept it to be correct, but technically you are stuck.
Because in the representation, my lord,
Because the wording in the tender document is so designed,
my lord,
that the contract has to be filed. Unfortunately, you have not signed the contract for third year. Technically, you are stuck. What to do?
Submission is this is my lord's rate contract which has been continuing, and the invoices for the same years have been.
You are
attached.
correct, but what to do? How to get out of this wording in a contract condition?
My lord.
Contract has to be supplied.
Annexer 5, my
Yes,
lord,
that one and knock you out.
Annexer 5, page 44, my lord, the reason of
Is
the
limited only to the extent that my representation be considered, and I'm not challenging the entire tender process, my lord. But because I have documents, because as your lordship
Which is the representation you want them to consider?
my lord, I have the substance.
My lord may kindly come to what is his
But what apprehension he has is maybe a genuine apprehension. In the next tender, you may disqualify. That's the reason.
No, my lord, lords may kindly
Can
come
we
to-
record that he can?
No, my lord, this will not stand.
He
This
may
will not.
apply.
He may
the
apply
future
future tenders, my lord.
We will record that.
Lords may
future tenders only that yes, my lord.
If you are qualified, let him participate in the
Yes,
future
ma'am.
tender.
Because
Future
my only
tender.
apprehension is for this financial year because of this dispute.
We will record that
We will
apprehension. Record that.
Like on
My lord, my lord.
this
He qualifies with other terms and
Yes,
conditions.
yes,
my lord.
yes.
polite on the last date, that is on 14/7/2025. When Mr. B.P. Tripathi, learned senior advocate appearing for the opposite party number 2 and 3, produced the copies of the relevant contracts executed by the petitioner for the financial year 21-22 and 22-23, along with the bid documents. And further stated that the bidder, that is the petitioner, has failed to supply the relevant contract document in support of supply contract for the financial year 23-24, and that he submitted only the invoices against the supply of the non-woven bags to private limited and public unlisted companies, which does not meet the requirements of clause 18.8 of the tender document. And therefore, the tender committee, after careful evaluation of the bid documents of the petitioner, rejected the bid.
But Annexer 5, ma'am.
Filed annexure
5. Annexer 5, page 44.
filed annexure 5. And those documents were handed over to the Mr. B. Vaibhav, freelance counsel appearing for the petitioner, he wanted to obtain instruction on those documents. Today, also, Mr. Vaibhav has failed to produce the contract documents for the financial year 2023 and 2024. And he fairly submitted that the documents which were handed over to him by Mr. Tripathi and senior advocates are his documents, and he has not filed any additional document. Stop. The Land Council for the petitioner submitted that a representation is pending before the opposite parties number 2 and 3, which was filed by the petitioner for consideration. And if the petitioner's bid document,
Nothing is pending, my lord.
Nothing is pending.
which is disputed by
Under Annexure 6, my lord.
Nothing is-
Annexure 6 to representation done.
see for Annexure 6 representation,
Yes,
But-
that is rejected.
which is disputed by,
My
just a minute, which is disputed by the Land Council for the opposite parties number 2 and 3. It is the apprehension of the Land Council for the petitioner that the petitioner may not be qualified to participate in the next year bid, since the technical bid has been rejected this year because of the non-availability of the contract documents for the financial year 23 and 2024. The Mr. Tripathi Land Council for the petitioner submits that
To the opposite
if
party.
opposite party submit, 2 and 3 submits that if the petitioner file the required documents, then
For
there is
future
no-
debtors.
Huh?
For future
Only
tenders.
For the future years, and there is no question of the opposite party number 2 and 3 not considering the same in accordance with law. In view of such submission made by the Land Council for the opposite party number 2 and 3, and in view of the limited nature of scope available with this court to interfere in the tender matters, in view of the law laid down by the Honorable Supreme Court in case of so and so tender or decision, we are not inclined to accept the prayer made in this writ petition. Accordingly, the writ petition being devoid of merit stands dismissed. Yes.
Stay interim stay to be vacated.
Interim order passed under undated so and so stands vacated.
Your assurance is taken on record.
Yeah.
My lord, my lord, my lord. That, my lord, whenever he will file, my lord, any tender comes up, he will file the documents, my lord. that will
Naturally, that
consider
is
fine.
Yes, ma'am.
My lord, pardon, my lord. My lord, item 24, I could not attend, my lord, please. My lord, due to power cut and
ଯେତେବେଳେ ଆସିବେ ଗୋଟେ ମଝିରୁ ମାଗିଦେବେ accommodation ଆପଣଙ୍କୁ ଦିଆହେଇଯିବ. Item 24 we have not reached there. We took up this matter because it was mentioned in the first hour. You wait till the matter reaches. Yes.
sorry, my lord.
What's the matter serially?
Item 7.
Several manner. Person for lordship's order, my lord, the petitioner filed an affidavit that he is willing and ready to deposit rupees 1 crore 20 lakhs. The full and final settlement of the loan amount under the OPM.
This you have been telling since last 2-3 occasions.
No,
Very
your lordship direct me to file an affidavit to that effect. That's right.
For OP 1 and 2, my lord, I have instruction to appear, my lord. Let him supply a.
bank is interested to see the color of the note, that's all.
Well, I am ready.
ସେ ଆପଣଙ୍କର ମୌଖିକ ଆପଣଙ୍କର ଯୋଉ ସତ୍ୟପାଠ ଏହା ଦେହରେ କିଛି ମୂଲ୍ୟ ନାହିଁ. ତାଙ୍କର ପଇସା ଦରକାର. ଆପଣ 1,20,20,00,000 ଟଙ୍କା ଦେବେ କି ନାହିଁ?
Again,
ଯଦି ଦେବେ ଡିପୋଜିଟ୍ କରିଦିଅନ୍ତୁ, we'll ask them to consider. Otherwise, affidavit ଆଜ୍ଞା ମୁଁ କରିଦେବି ଏସବୁ ଜିନିଷ.
The litigation, because of the litigation, pendency of litigation, they are not able to take litigation.
my lord, I have one thing now. I have filed an affidavit that within 3 months we will deposit. My lord, in the 125 days has already been allowed to the filing of the affidavit. So within that period, rest 2 months, my lord, I will deposit 3 lakh, entire amount.
We are not the bank.
I do admit, let them accept, my lord.
No,
We can't force them to.
you are to convince them and all these things.
Otherwise, my lord, they will not accept my.
We will simply say that the affidavit which you have filed will be considered by them. That's all. Beyond that, we can't say.
Kasturi, you are appearing for whom?
For opposite party 1 and 2 bank, my lord.
File करछन्ती appearance memo.
मैं appearance में file
माने वकालत नामा फाइल करछन्ती.
मैं appearance में file करने it is
करनांती हम तो dispose of कर दो ना. अब bill देलाउड असुविधा हो.
from Jonah, I have my instruction has been come to appear on their behalf. My lord.
हमें
Yesterday night only I could come to know, my lord. That
just
was that.
can you obtain that wakalatnama and file it so that when we dispose of the case, it will not create any difficulty on your part to submit your bills, etc. Because that is what we want. We are disposing of, but if you can file the wakalatnama, please file it, right? Look, this writ petition has been filed by the petitioner Nanda Kishore Panda with a prayer for a direction to the opposite parties number 1 and 2 bank to consider the OTS proposal as per the order of this court dated 3/1/2024 passed in WPC number 41363 of 2023. The C. Kasturi Land Council has appeared for opposite parties number 1 and 2.
1 and 2.
Ethical Lekuju, Jadi Wakalatnama file for the and files Wakalatnama Adaba. But the time is given to you up to by 2 o'clock or 3 o'clock to file. Because we are signing the order after 4 o'clock. So please do this. Jadi file from the when a submission was made by the Land Council for the petitioner, that the petitioner he will obtain the instruction regarding the readiness of the petitioner to deposit a sum of rupees 1 crore 20 lakhs before the opposite party number, opposite party bank. We adjourn the matter and today ये affidavit केवे file करले?
23/6.
And an affidavit has been filed by the petitioner. It a matter to them. It a केवे करा होगा? सही दिन file कर दे संगे संग. On the very day, the petitioner filed an affidavit wherein in paragraph number 2, it is stated as follows. Quote paragraph number 2 of the affidavit. In view of such affidavit, we dispose of the writ petition without expressing any opinion on the merits, that it is open to the petitioners to approach the opposite party's bank for consideration of the OTS proposal in accordance with law. And in view of the order passed earlier by this court in WPC number 41363 of 2023, dated for the 3/1/2024. Accordingly, the writ petition is disposed of. Yes.
Item 8.
Instruction to appear for one. Yeah, I have instruction to appear for one.
No, who is the petitioner's counsel? Mr. Tukuna Kumar Mishra. You have instruction for ICS.
ICS 1 and 2.
File karibe na korchenti.
I will do.
They give file it. Liam. Mr. Naranikanta Das and his associates have filed power for the opposite parties number 1 and 2 bank, which is taken on record. On appeals for the petitioner, let this matter. I urgent present who is after the names of the learning council for the opposite party number 1 and 2 be reflected in the cause list henceforth. Enough?
Item 9.
May I please, Your Lordship?
Yeah.
The erstwhile landowner, in respect of 2 parcels of property, executed registered leases in favor of Hindustan Petroleum Corporation. The lease,
You have received the copy of the letter. What is your prayer, Mr. Mukherjee, in this question?
I have prayed that there is an order of attachment made by the recovery officer in respect of the property. Lordship may kindly take page 12.
That is 9/5/2025.
Huh?
9/5/2025.
Yes. 9/5/2025.
So that was as per the order of the DRT,
Recovery officer.
right?
Yes,
order on-
DRT. DRT has passed an order,
Yeah.
and what I prayed for is that my rights need to be protected in line of the Transfer of Property Act and the line of judgments rendered by
the case in which this order was passed, whether that case was disposed of or still sub judice.
It must be pending.
Must be pending there.
No, that my application was rejected. That order I have annexed.
Now, against an order of recovery officer,
Yes.
you have to approach the DRT only.
No. I kindly see this order. Attachment order. It is not an order. My intervention application. Kindly see page 61. That's the application where my application was taken up for consideration. And at page 62, the bold portion. From the above, it is clear that the intervener has no locus standi to file the petition for intervention. In view of the above, as contended by the petitioner, is beyond the jurisdiction of the recovery officer, hence both IAs are hereby rejected.
No, Mr. Mukherjee, this order was passed in 2023. Now, by virtue of this attachment order which was issued on 2025,
Yes.
if you are aggrieved, then you can at this stage also file another application showing that how you are aggrieved, how we are going to, so that can be considered. Why you are not approaching
Before DRT.
Because that was passed in 2023.
Yes, my intervention was rejected.
Right.
Thereafter,
Now-
he has gone on to attach the property.
Right. Now
And
you are
that's
affected.
directly against the statute.
No, whatever it may be. Now the attachment order which has been passed that affects you.
It affects me.
It affects it means you are a necessary party. Now you should bring.
But on the face of this order, how do I again go to
No,
the
because of the change in the, by that time this attachment order was not issued. It has been issued recently in 2025.
Yes.
Your intervention application was rejected in 2023.
No, intervention application rejected because the recovery officer doesn't have jurisdiction, rightly so. It is only the DRT has jurisdiction to enter in application, not the
Otherwise, also
recovery.
I do not come into the picture. It is the duty of the bank. Because the statute says when it took mortgage of the property, there was already an encumbrance of a registered lease in my favor. My lease predates the mortgage. The mortgage was created in 2005. My lease is subsisting since 1993. And it's a registered lease. So under the statute, under the provisions of the Transfer of Property Act as well as the Sarfasai Act, it is the duty of the bank to discharge the encumbrance before it proceeds.
Right. All these things are to be brought to the knowledge of.
I had brought it to the notice of the bank. The bank has ignored it, not once, twice.
But
during pendency of the case.
What we are telling you that DRT is in session over the matter.
The DRT is no longer. They have passed a final order, which is now before the recovery officer. The final order has already been passed by the DRT.
Recovery officer is only to execute it.
Yes. Because the final order has already been
And
passed.
the application which you moved, the intervention application should have been decided by the DRT, not the recovery officer. Recovery officer doesn't have any jurisdiction.
Well,
So rightly so, he has rejected. You move to DRT, we will give that liberty.
Your Lordship, kindly have a glance.
Let
to
the DRT decide your application.
Section 30 of the, my lord, recovery of debts and due to Banks Act, my lord. There are only 30 against the order of the recovery officer, appeal to the, my lord, presiding officer.
That's that.
which one?
But section 30 of the recovery of debts and bankruptcy act, 1993.
30 section
33,
thirty.
my lord.
While your lordship is seeing 30, your lordship may also see 30 capital A.
That's got appeal against the order for recovery officer. Notwithstanding
That's right,
anything.
that's always.
Yes.
All right, we are giving you liberty approach. Yes, Mr. This petitioner Swanson has filed the application with following prayer. For all the prayers, the Mr. Mukherjee and senior advocate appearing for the petitioner submits that is aggrieved by the order dated 9/2/2025 passed by the recovery officer under Annexure 5, which is the warrant of attachment.
9/5
Immovable, no, like 9/25. The land council appearing for the UCO Bank, Mr. Swine submits that in view of section 30, the petitioner has got alternative remedy and stop. Section 30 is quoted here in below for the entire source. Since the order is appealable. Before your lordship proceed to, there is one clarification which I require. There's just one clarification. May I just submit before your lordship
Complete.
proceeds with the order?
1 minute.
Yes, sir.
Complete.
Just call for dictate the order. That portion. Look, that-
No, since the intervention application filed by the petitioner has been rejected by the order dated 23/6/2023 by the recovery officer, inter alia, stating that he doesn't have the jurisdiction to entertain that application. The against the said order passed by the recovery officer dated 23/6/2023, remedy under 30 is available to the petitioner. It is open for the petitioner to resort to the said remedy.
Just one more clarification.
Yeah.
Under section 30 capital A,
Yeah.
there is a requirement of a deposit.
No.
Now, this deposit is being grossly misinterpreted by the tribunal in all cases, where even though a person is neither the borrower nor the guarantor, he is also being asked to make the deposit.
You move an application for waiver.
Your lordship may clarify that.
The learned Mr. Mukherjee submits
Neither a borrower nor a guarantor, and hence the deposit cannot be.
section
No
30,
case for waiver.
section 30A regarding deposit of the amount of debt may be a problem for the petitioner who is neither a borrower
Nor a guarantor.
nor a guarantor, and therefore the said provision is not applicable to the petitioner. We
He may move.
if the petitioner moves any such application, then it is expected that the learned tribunal shall consider the same in accordance with law.
Obliged.
According to the petition.
The lordship may grant me 10 days time to move that file the appeal, because otherwise the
30 days
limitation.
limitation, it has gone long back.
Long back. And before this order, so section 14.
The Mr. Mukherjee submit that the petitioner will file the appeal under section so and so within 10 days. Accordingly, it is disposed of.
Obliged.
We are just coming within 2 minutes.
Item 10.
Wait, please. It's Annexure 3 is the order passed by the Grievance Redressal Forum, which is the subject matter of challenge minutes. The opposite party had moved the Grievance Redressal Forum for shifting of a transformer, electricity transformer. After hearing the parties, the learned GR have passed an order to find a suitable place and shift the transformer. The difficulty is that the GRF, learned GRF, does not have jurisdiction to adjudicate that dispute, which solely lies with the concerned district magistrate or the commissionerate police as per the Telegraph Act. This particular dispute had been settled by this honorable court in a similar
Why
manner.
you approach you yourself approach?
No, we have
No,
for the
we also-
licensee, the opposite party had
Opposite party.
the same, whether GRF has the jurisdiction or not was the subject matter.
What was the prayer made in that complaint case?
It's page number 14 to shift a electricity transformer from one place to another.
Come to the prayer portion.
If your lordship sees, the prayer portion is at page number 18. To remove the structure of district, your lordship gets it?
No, after allow the complaint by directing
The OPs to remove the structure of the transformer, distribution transformer installed unauthorizedly in the private lot of the petitioner immediately within a week, further to pass order for payment of adequate compensation and litigation costs, etc. for mental harassment and agony. This was the prayer. Now, that has been partially allowed by the learned GRF. This particular case,
what was allowed?
Direction was passed to shift the transformer from one place to another place.
Where is that portion? Let us see.
Page number, if your lordship sees, the operating portion is at page 34. That would be Annexure 3.
To shift the transformer to a suitable place.
A suitable place, after consulting, both the parties should consult the local people to find a place. And then that particular judgment which I have handed over to your lordships, if your lordship sees, para 2 of the judgment is the same subject matter of dispute. The GRF directed the petitioner to take all necessary steps to remove the transformer having capacity of 500 kVA from private plots of the complainant to a convenient place. The operating portion is at page 35, paragraph 33. 35, if your lordship.
36 is the.
Yes, 35 is the observation, 36 is the last.
Either the district magistrate or the commissioner of police.
Yes.
If he has so authorized, exercise the power, the authority, and with the such dispute.
35 says we are of the considered view that the GRF did not have requisite jurisdiction.
Good.
35 starts with we are of the considered view that the GRF did not have requisite jurisdiction to entertain the dispute relating to shifting of the transformer in as much as by the rules and practice direction as framed under section 164 of the Indian Electricity Act, it has been clearly provided under Rule 3 of the Works of License Rules that any time the owner or the occupier of any building or land from which any works have been carried out or any support of an overhead line has been fixed, shows sufficient cause, the district magistrate or the commissioner of police or officers so authorized may give an order in writing directing any such work support, stay or struck to be removed or altered. This provision has been supplemented by the provision of order dated so and so, which are substantially pari materia to the provision of Rule 3 of the Works License Rules 2006. 36 is the operating portion quashing the GRF's order. And 37 is the liberty granted to approach the concerned district.
Hearing notice has not been issued.
First time.
Notice you.
No.
The petitioner, executive engineer, so and so, has filed this writ petition challenging the order dated 5/4/2023 passed by the Land and Grievance Redressal Forum GRF Bhubaneswar in complaint case number 62 of 2023. The Land Council for the petitioner submits that the opposite parties filed a complaint case under section 42(5) of the Electricity Act, read with OERC, GRF and Ombudsman bracket ends Regulation 2004. With the following prayers, quote, the prayer portion.
Page 18.
Page 18. The said complaint case was registered as CC number 62 of 2023, bracketary BED, and the London GRF had impugned order dated 5/4/2023 has been pleased to order as follows. Quote, paragraph number, page number 34. Citing a decision of this honorable court in the case of executive engineer so-and-so versus so-and-so reported in so-and-so. The land council for the petitioner was that the land GRF has no such power for directing shifting of the transformer. The operative part of the order are quoted in the aforesaid decision in the case of so-and-so is quoted here in below. Quote paragraph number 35 and 36. Stop. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Requisites for issuance of notice by speed post with proof of delivery to be filed within a week. Put of this matter 4 weeks after. Counter affidavit, if any, be filed. In the meantime, IN number so-and-so is an application for stay of operation on the order dated so-and-so. After going through the averments taken in the interim application and hearing the land council for the petitioner, let there be a stay of operation of the order dated so-and-so until further orders.
Item 11.
May be permitted to withdraw. Permitted to withdraw, I have filed
By
a
the
memo.
memo.
Give a memo.
Yes, already mallards that has been, back pay mallards.
Good.
Black K.
Achha, the memo has been filed, which is at flag K for withdrawal of the writ petition. The writ petition is disposed of as we come. Yes.
Item 12.
Also, last order we have already filed objection to the delay application.
Delay is there.
99 days delay. There are absolutely no reason assigned. This is virtual manner written is I was suffered from jaundice and gastritis. Therefore, I was under treatment.
One medical certificate has been annexed instead of medical facilities.
The private doctor certificate that he was ill. Who are class 4 employees working in a.
What is the writ appeal for?
Writ appeal challenging the order passed by the London honorable single judge.
What was you are the petitioner in that?
Yes, sir.
So what was your prayer?
My prayer was allegedly I was terminated from the service. The order of termination was challenged before the director of secondary education. The director of secondary education rejected my appeal, and that appeal was assigned in the writ petition. The writ petition, the honorable single judge quoting the judgment, aspect of judgment, can come to page 10. Page 10 of the order, subparagraph. The only ground adduced by the London advocate for the petitioner is that the natural justice has not given in termination of the petitioner. The advocate on behalf of the MC produced postal receipt to the effect that the so-called notice were sent under certificate of posting, which the advocate for the petitioner asserts at first. Without entering into a conclusion on this point, it is observed
In 2024, when the school was a long way from GIA and the private management of a rural location may not be aware of the need of the proper record keeping. A private high school with the handful of employees is not that a big an organization where the petitioner could not know the feelings and view of the headmaster and MC. From the development stated above, it is clear that petitioner had lost the confidence of his employee and was aware of the possible action that would be followed. But he was not challened. Now, when the school come to GIA poll in 2015, he is raising the issue with an eye of the GIA. It will be unfair if errant employee will be given fresh opportunity through re-entry and visit.
So from 2001, January, you remained absent.
Yes.
And different correspondence were made, and ultimately the managing committee took the decision terminate, and that too in the year 2004. Then you this code for the first time in 2019 and first 2016 you came, and so that was disposed of because the appeal is there. Then you preferred the appeal, and the appeal also went against you. The appeal order that you challenged here.
No, but fact remains the order of termination was not handed over me or served on me. The plea of service of the under separate posting is not legally sound.
That must have been adjudicated by the that appeal. That
has not been adjudicated. They stated that without going into the controversy. Whether service of no.
So managing committee just decided to terminate you as such, or initiated any proceeding and issued
They
notice
stated
to
that
you.
in proceeding was initiated, but the order of termination was not served on. They are pleased that they sent the order of termination through under certificate posting. That is not the process. They should have sent through registered post or sub copy on through the office.
Well, that is a ground for, let us say that's a ground for delay in approaching this court, but your appeal has been entertained. Now the question is that an employee who was there remained absent for 3 years and shows no interest.
That ground may not be available to you insofar as this petition is concerned, for the simple reason that in 2016, that ground was available to you, you availed it, and you file an appeal against that, which is turned down in 2019. Then it was served or not served, those grounds have now not available to you. And in the condonation of delay, you say that for 1 year you are suffering from jaundice.
More than 1 year.
More than 1 year.
The court must
And you'll also already decided in the recent judgment, you'll also do that condonation delay.
No, liberal attitude should not be there.
Yes. The detailed judgment, details. And in that case, delay was only 320 days. Here was 399 days.
And you got a certificate from a homeopathy doctor.
Yes.
Yesterday.
CORAM
So
You will also as well as sitting with Justice Ms. Raman. This is a recent judgment relying on number of Supreme Court judges.
IA number so and so, this is an application for condonation of delay. The stamp reporter has shown that there is delay of 399 days in filing the writ appeal. Grounds have been taken in the interim application that the appellant fell ill on 19/10/2019 as he was suffering from jaundice and severe gastritis and was under treatment of the doctor till 22/11/2020, and he became fit on 22/11/2020 to resume the normal duty. And after recovering from the illness, the appellant contacted his lawyer, and then the writ appeal was filed on 23/11/2020. It is further stated in the delay condonation application that the delay was neither intentional nor due to deliberate laches on the part of the appellant, and prayer has been made to condone the delay. In support of the averments taken in the application, a certificate issued by homeopathy doctor dated 22/11/2020 has been filed, which simply says that the petitioner was suffering from jaundice with severe gastritis and was under his treatment from 19/10/2019 to 21/11/2020, and he became fit to perform his duties daily work on 22/11/2020. The respondent number 5 has filed.
Four, I am fine.
5 file objection.
I have also filed.
Thank you. Objection, right? The respondent number 5 has filed the objection opposing the condonation of delay, and it is stated in paragraph number 5, 4 and 5 as follows. Quote paragraph number 4 and 5. দিয়ন্তু আপনার দিয়ন্তু সেটা নিয়ে আসলো সামনে। The respondent number IA number to সমান ছিল। The respondent number 4 has also filed the objection. Siya to lagi dibe wherein also similar objection has been made. The land counsel for the petitioner submits that a sympathetic view may be taken. However, the land counsel for the opposite party number 4 and 5 placed reliance in the order dated 26/3/2025 of a division bench of this court, passed in IN number 3691 of 2022, in WA number 1572 of 2022, where prayer has been made to condone the delay of 320 days in filing the writ appeal. After taking into account the ratio let down in various cases, this court was not inclined to condone the delay. After hearing the land counsel for the respective parties and going through the order placed by the land counsel for the respondent number 4 and 5 and the amendments taken in the interim application, we are of the view that the petition for condonation of delay doesn't demonstrate sufficient good cause. And as such, this court doesn't deem it as a fit case deserving condonation of inordinate delay in filing the writ appeal. In view of the above discussions on the facts, on the discussions further, the interlocutory application is dismissed. Consequently, the writ appeal also stands dismissed. Yes, next.
My objection, I mean, collection letter, my
No, that is to be filed for we are just bringing it, then it might be written. Yes.
Item 13.
This is the petition for restoration of the writ bill, and Tribunal court in the month of March issued notice to the sole respondent.
What happened?
But the notice has returned that in such address he is not staying.
So you have to furnish the fresh address. The correct address now you are.
The address, may kindly appreciate, that is the address basing on which he has.
That's all right, but he is not available there now. So you have to find it out. You are the petitioner. The court will not go and search that where that man is.
I oblige my lord, that is not the fact. Fact is that when I have filed this petition for restoration of the writ appeal. If your lordship will restore the writ appeal.
No. How can we restore the, you, sir?
Because he is not available in that address.
In the writ he was appearing.
Because, pardon,
in the writ petition, was he appearing?
Yes, he was appearing through counsel in the writ appeal, my lord. In the writ appeal, what happened, my lord? In the writ appeal, during the corona period, he appeared and filed a memo without my knowledge. And I missed the list, as a result of which it was dismissed for default. And that is the, because your lordship may kindly appreciate, I have stated all those facts in my petition also.
To counsel you can, sir.
So you serve on at least
during the corona period.
To counsel you, sir.
The very counsel who are appearing in that writ appeal,
if your lordship,
the respondent,
if your lordship will pass,
they may take instruction whether.
Yes, if your lordship will pass an order that I have copy on the counsel for the.
All right, they may take instruction and sir.
Yes, my lord. I'll serve a copy on the counsel appearing in the writ appeal.
Yes, obviously. IN number 1, so this is an application for condonation of delay. As per the order dated 26/3/2025, notice on the question of limitation as well as admission was issued to the opposite parties by registered post. The land counsel for the petitioner submits that requisites have been filed. However, the notice has been returned from the sole opposite party with postal remark, addressee cannot be located, hence return to sender. The land counsel for the petitioner submits that the एमिति लेखिले कोडी जीव ब्रह्मानंद कहर आपण कोन लिखिजन देखिले आपनकर जो रिस्टोरेशन पिटिशन देइछंदी सीएमएपीएल एड्रेस को आसन ऑपोजिट पार्टी देइछन आपनकर ये रिट अपील ले पड़े आसन रिट अपील को आसन रिट अपील मेमो देखंदु
I may pardon my lord, that is a typographical mistake.
No, you correct it and file press it. Pura bapana
there is nothing.
How can
How will you locate the person?
Aman je Kottagre khali janaga na lende ko Kottag.
I am extremely sorry, my lord. That is escape my lord.
The land counsel for the petition submits that he has not furnished the detailed address of the opposite party in the cost title, and that may be a reason for which
No, in the notice, your lordship may can glance in the notice.
No, you do it, you correct it.
Notice, I have given the detail.
No, you send once again. Look on the for which the notice might have written on delivered, and he will take steps for amendment of the post title of the CMAPL by filing appropriate application for mentioning the correct address, the detailed address of the opposite party.
And serve advance copy on the council appearing.
And also serving an advance copy of the CMAPL on the London Council who was appearing for the opposite party in writ appeal number 772 of 2015. Put up this matter on such and such date. Necessary steps be taken in the meantime. Yes. Put up.
हाँ हाँ आगो जो डकायत कर सारा बुदा के लिए ना
Pardon, I will file a petition.
You are to file one
Petition for amendment.
You are
Or only amending the
of the cost title ro address ta opposite party ro address. Number 2, you are to serve a copy
yes, ma'am.
of the CMAPL and that IA on the council who was appearing for this opposite party in that writ appeal. This is the thing, okay?
Only by amending.
अरे पुण आपण कोण एटा हमें dictation दबो ना
I move
yes
clarity. Amendment फिर आउटर.
Please see the order in the evening hours, okay, and do the necessary. Yes.
मैंने amendment आउटर आसी order करना
Obviously ଆସିବ କଣ ସେଟା ନୂଆ କଥା ନା ଆଇଏ ସେଇଥିପାଇଁ କହୁଛି ପରା ଏ ଆଇଏ ର ଏ CMAPL ର କପି ଆଉ ସେ ଯୋଉ ଆଇଏ ର କପି ଫର condonation of delay along with ଯୋଉ ଆଇଏ ଟା ଫାଇଲ କରିବେ for correction of that cost title, all these 3 things are to be handed over to the council who was appearing in that writ appeal.
Sorry to trouble your worship.
No.
I'm obliged.
Sorry. Yes.
Item 14.
MPL, dismissed only because my name was not reflected in the court list, madam. I had filed the Oklatnama.
No, there is an application for condonation of delay.
Yes, sir.
What is the delay? Pointed out. Yes, sir.
640.
Fine.
My name was not there, I could not.
Just a minute. 612 days delay.
Yes.
So notice has not been issued. All right. IN number so and so. This is an application for condonation of delay in filing the CMAPL. Stop. The stamp reporter has pointed out that there is delay of 612 days in filing the CMAPL. Stop. Issue notice to the opposite parties
1 to 4
on the
and 6.
question of limitation. Stop. No notice be issued to opposite party number 8. Stop. Land Council for the state accepts notice on behalf of opposite parties number 1 to 4. Extra copy of the CMAPL, so also the IA be served on the Land State Council so far as the opposite parties number 5, 6 and 7 are concerned. Requisites for issuance of notice on such opposite parties be filed within a period of 1 week. Yeah. This is matter on such an objection, if any, to the delay condonation application be filed. Yeah. 2 weeks.
Item 15.
Yes, sir. When it is considered not the registered speed post, we file the requisites of the registered post. That's the
Portion to this one also requisites for assignment file by register post instead of. That is to be accepted. The requisites filed for issuance of notice on opposite parties number 2 and 224 by registered post with AD be accepted and office to proceed accordingly. Yes.
Item 16.
And for the petitioner, I am on virtual mode, my lord. Lordship kind see your lordship's order dated 12/2/2025. I have immediately served the copy. Opposite partner 1, 2, 3 are the employees of the Coalfield of India. Opposite partner 2 and 3, 1 and 3 has already appeared, and I have served the copy for opposite partner 2. All are appearing for by the one counsel. And 6 months have passed, they have not filed the counter.
And filed the active report to the bank. Yeah.
I have duly served the copy.
You are appearing for
All the
respondents. Have you solved the copy of Mr. Mishra?
Just now, sir. To his associate.
I will collect, but in the course of the day, I will collect.
Please go through the affidavit we are taking of this matter next week or any day.
That's it, 10 days after, my lord. Meanwhile, let me examine. If required, I can file a reply.
Okay. Let me. The and counsel for the respondents file the affidavit which is taken in record. Copy of the affidavit has been sought on the learned counsel for the appellant, Mr. Mishra and senior advocate, appearing for the petitioner that 10 days time may be granted to go through the affidavit and to file a response, if any, put of this matter after 10 days. Yes. Yeah.
Item 17.
Mr. Rao. Mr. Padi is there. Just Mr. Naik.
Miller.
When the matter was listed last time,
Miller.
that is on 5/5/2025,
Yes.
you took time to obtain instruction whether you intend to file any counter affidavit or not.
Miller, letter has also been issued, but no response. But the case record, as per the direction.
No, that is all right. When we are noting down that the state does not intend to file any counter affidavit, it is up to you.
One instance, my lord, I'll obtain. On 9/5/2025, letter issued to the additional.
Because the central government council has already filed the counter affidavit.
Will you file it or not?
One chance, no.
So when you want that?
One captain.
So let it be on 28th and take positively that whether you intend to. Mr. D.R. Bhuktan का नाम लिखा है जी.
Yes, D.R. Bhukta will appear in this case. D.R. Bhukta will appear.
अच्छा. As per the order dated 5/5/2025, the Learned Council for the state took time to obtain instructions whether the state intends to file any counter affidavit or not. Mr. Naik, when additional government advocate, 6 times till for a week to obtain the necessary instruction in that regard. Non appears for the, you are appearing for petitioner. Land counsel for the petitioner is present, so also the land counsel for the Union of India. Stop. Put up this matter on 28th of July 2025. The land counsel for the state shall apprise this court about the filing of counter affidavit, if any. Yes, next.
Item 18.
May I agree. In the cause list, there is a noting that opposite party number 6 has a highly counter. But I have not received copy of the counter. This is a matter related.
Who is the opposite party number 6?
No, I have.
Give the counsel.
I am sorry. No.
And the Union of India has already filed.
My lord, counter agenda and reply to agenda already filed.
Mr. Rayaguri, you are also appearing for opposite party number 6.
Yes.
Okay. So what do you want? You want to go through the counter affidavit?
My lord, because this is a matter relating to permanent absorption of the petitioner.
Uh-huh.
Permanent absorption of the petitioner who is on deputation in the with the opposite party 1 to 5. 6 is the lending department, my lord.
So whatever it may be, you want.
So I want to file a rejoinder to this matter.
Okay, that is all. Have you filed any rejoinder to the earlier counter affidavit?
Yes, my lord.
They have filed.
They have filed a reply to rejoinder.
The land counsel for the opposite party number 6 has served a copy of the counter affidavit on the land counsel for the petitioner in court today, who seeks some time to file the rejoinder affidavit. What time?
2 weeks.
2 weeks time to file the rejoinder affidavit.
And I have also served a copy of the news case. One IA has been filed for vacation of interim.
Asha. That is 18936 of 23.
Yes,
the copy of the interim application, that is IN number 18936 of 2023, filed for vacation of stay, has been served on the land counsel for the petitioner. Put up this matter in the way commencing from 4th of August 2025. Rejoinder affidavit, if any, to the counter filed today by the opposite party. Counter of the opposite party number 6. So also objection to the IA we filed in the meantime. All right, here.
Interim order to continue.
There is an interim order. It will also shall continue. Next.
Item 19.
My lord, may kindly permit me to move this item. My lord, a consumer representation was filed before the GRF. Without issuing notice, the GRF passed the order against me, directing disconnection. I went in appeal before the Ombudsman. Ombudsman confirmed it. He relies upon a agreement saying that the person who made the application, he says, I am the owner of the property, I am just a tenant. But in that agreement, your lordship will see, my signature is not. Even so, madam, when an application is being filed against me, at least I should be heard, given an opportunity of hearing.
Who has filed that application?
The application has been filed by one S.Mishra.
That is opposite party number 4. Where is that application?
Yes, application, your lordship may kindly see. That application has not been annexed, but the impugned order of the GRF has been annexed.
Where is that?
My lord, Annexure 7, page 58.
Annexure 3, madam. Annexure 3, page 21.
3 na 7?
So, madam, 7 is ombudsman. What my learned senior is referring to?
That is, we are the first one. That is
First one is, my lord, Annexure 3.
Annexure 3.
Page 21.
This was filed by
one S.Mishra, whom I made a package.
Okay. And you are not made added as a party?
No, my lord, I had not been made a party there.
Because it is another bill किसी नहीं.
No, another bill नहीं, certainly TPCODL opposite party.
Then when it was you are not made a party, so the question of issuance of notice does not arise.
My lord, once.
But if it is against you, then it is of course.
Yes,
it
your
was
lordship,
that
you
you should
see the
be.
Who are
last.
you, by the way? Who are you?
My lord, I am in occupation of the premises.
The capacity is
I am an occupier.
in what capacity?
I am in possession of the property.
In what capacity?
No, you
Are
must
you
have
a
been-
owner or a tenant or permissible possession? Who are you?
My lord, I am in permissible position. I am in permissible position, but I am taking a stand that he is not the owner of the property who can file an application against me. Even so, my lord, whatever may be the cause, but at least, my lord, I should be given an opportunity of hearing. And when the court finds out that he will disconnect, then he should at least give a notice. And once I file it before the
You produce that. Let us see that complaint petition, because from this order it is not clear the what is his averments, what he has taken, that all these things.
Why has he filed for disconnection? That's the important thing.
he is claiming to be
Connection is something different. Disconnection is something else.
You
There
might
must be
not,
some mitigating circumstances.
might not be leaving that place in spite of some court order. It is mentioned that there is a civil suit was there and some order was
which
passed.
has been dismissed. I have annexed that document.
Against that, the appeal was before the High Court. It was appeal RFA was filed, and RFA was transferred from the High Court to the
So many
District Court.
book history is there.
So,
My lord, may kindly turn to page 35. The Sarawala Mishra, who is the mother of the grandmother of the present OP number 4, filed a suit. Suit was dismissed. Suit was dismissed. Unless it is varied in a superior court, that holds good. And now, in the other way, he files an application and gets the disconnection. I go to ombudsman. Ombudsman also doesn't hear. Ombudsman would have relegated the matter to the court below for hearing in my presence.
Why disconnection, Mr. Maharana?
Let's see what has happened. The petitioner herein, he claims that the property belongs to the grandmother. The grandmother given the opposite part number 4. Opposite part number 4 says that the property belongs to the grandmother. He is a tenant. The present petitioner is a tenant. Now there is a dispute between the tenant and landlord.
That's the real.
So it's the indirect way of
In order to remove the tenant, a disconnection was prayed for and it was allowed.
It was allowed.
So it's the indirect landlord-tenant issue.
And OP4 has been noticed. He has filed a counter in this matter. I think Mr. Mishra is appearing. He's not there. For OP4, he has filed a counter also. Mr. Soumya Mishra, let's say, he was appearing.
That's the problem. A tenant is removed. In order to remove a tenant, a disconnection was prayed. A disconnection was allowed. Indirectly, the eviction is ordered.
And interestingly, Malas, land belongs to government. Adverse possession was claimed, dismissed, pending RFA.
the counter affidavit is very clear on the opposite party number 4 also elaborately. So you have also filed a rejoinder to that counter affidavit.
Yes. Yes, ma'am.
All documents you file, it needs to be adjudicated.
The main ground, Mr. You are taking that you are a necessary party, but the order was passed against you.
Yes.
But you have not even noticed, and on the very fast date, this what so far.
Yes.
So.
You have been rightly used.
Well, the licensee has been rightly used.
You filed that
The application.
and because Mr. Mishra is not there.
The application is with them.
I'll file all the documents.
You file it.
Yeah.
Right.
Okay.
Entire pleading you file.
Yes, sir.
This
Now still you are in position.
Yes.
even after disconnection?
Yes,
What are you doing there?
my lord, I have a shop room there.
The petitioner,
Your lordship has said disconnection.
Braja
Your
Kishore
lordship has
Barar,
protected that way.
has prayed for quashing the order of the GRF and GRF Dhenkanal TP CODL dated
30/11/2022.
30/11/2022. TP সেটা হচ্ছে opposite party number 2. So also the order dated 9/6/2023 passed by the opposite party number 1. Holding that the London GRF has rightly directed the opposite party number 1 that is the executive engineer electrical DED মানে কোন?
There's Dhenkanal Electrical Division.
আচ্ছা Dhenkanal Electrical Division TPCODL, Dhenkanal to disconnect the electricity supply of the petitioner - consumer and confirm the order passed by the London GRF. Mr. Bose, Land Counsel, appearing for the petitioner, at the outset submits that the complaint case or the GRF case number 200 of 2022 was filed by the opposite party number 4. And in the said case, no notice has been issued to the petitioner. Though it has been, the order has been passed for disconnection of power supply, giving illegally to the petitioner over plot number 5645/7470, in which he operates one vehicle serving south. The Land Counsel for the petitioner has not annexed the copy of the case which was petition which was filed before the London GRF Dhenkanal TPCODL. The London Counsel for the opposite party number 4 submits that he will file the said petition by next week.
Yes.
Put up this matter on recommencing from 28th July 2025.
And you tell us on the next date of hearing whether in the regulation, whether a spot inspection is mandatory before passing the order of disconnection. Under the regulation, it is there. Not on the basis of the pleading you decide. It is obligatory on the part of you to visit the spot to see whether disconnection is sought for is genuine or not. Under the regulation, there.
I'll show you.
That part also you just.
Yes, ma'am. I'll clarify.
Item 34.
Because it apparently appears that no inspection, nothing was done. If you would have done it, who is the occupier would have come to the light, you know, since you have not done, obviously.
Hello, please.
Item 34. Notice is to be.
On Friday, where you mentioned. All these matters will come.
That matter, we have to file an affidavit direction. I put 2 weeks time.
Put a
Item 20.
20.
You have to file,
Both parties, the opposite party and mine also to file affidavit. Their direction 24/3/2025.
24.
2 weeks time is also.
This case, I am also appealing to the petition number 2. And on the last occasion, the Lordship was pleased to direct me to file a system
all right, the London Council for the opposite party number 2 as well as opposite party.
Petition.
As well as the petitioner. Seek for an adjournment to file the affidavits as was ordered on 24/3/2025 and 1 week time.
2 weeks time.
2 weeks time. It is this matter will be commencing from 4th August 2025.
No, Item 26. I'm appearing for the OP number 5 and 6. Size there for the petitioner.
I'm on behalf of Mr. Swine in item 26.
Yeah.
26 milods, Ray milods, I am for IDCO milods. 26, we have instruction there that they will sort it out, the matter will be sorted out. Lordship will grant some 10 days time, after that immediate Lordship. By that time.
It will be referred to the mediation or you yourself?
No, this is regards that option purchase.
This is a matter wherein, based on the legal notice given to IDCO, the IDCO has stopped my registry, wherein I am a successful auction purchaser.
You are appearing for whom?
For IDCO milods, if we want to.
By the High Court's order.
Want to settle it out of.
Milord, that-
Have you issued any notice to in that respect?
No notice, my lord, only my lords on the basis of an.
You have got the instruction that all right.
We have.
The London Council appearing for the IDCO. This is item number 26. That the matter is likely to be settled between the parties, and it may be the matter may be listed after 2 weeks. Right? Any order, interim order was passed?
No, but I request your order to fix a date.
No, obviously. No, the put of this matter. अच्छा, 4 तारीख रख लेता हूँ.
4th August.
That is the calendar.
4th August.
4th August 2025. Okay. Yeah.
Item 34, your lordship. I am for the petitioner. My learned senior is there on the VC. That matter wherein consolidated cost title was required pursuant to your lordship's direction on 14/7. That's there on record, your lordship.
Lordship, my presence may be recorded.
Yes, yes. Give the name so that.
OP 5 and 6.
Not a
Please give it. And who opposite party number to you? Opposite party number.
To be issued.
Which order you are referring to?
My lord, 14/7/2025.
34.
Item 34, your lordship.
Just a minute.
My lords.
Let him come. That was an order passed on 14/7.
My lords.
Application filed for amendment to include so and so as opposite party has been opposite party, no objection. Prayer is allowed. Permitted to so and so. Amended cost title to be filed.
That has been filed. It's there on record, your lordship. The noting says so.
Okay. The London Council for the petitioner submits that as per order dated 14/7/2025, the amended cost title has already been filed and the same is on record. And Land Council for the opposite parties, Mr. Das, Land Senior Advocate. You have already received, Mr. Das, that.
Yes.
The amended cost title, you have received now?
Yes.
That he has received the copy of the. So what do you want now?
Notice be issued, your lordship.
Notice is
Notice.
For that, you.
Your lordship, OSFC matter.
Order, all right. Issue notice to the main matter. Issue notice to the opposite.
Party number 5.
Number 5. Requisites for instance of notice on the opposite party number 5. We filed.
2 days, your lordship.
Within 2 days. And matter will be listed on speed post with to carry the.
My lords, speed post. Your lordship may kindly give me a date.
Will date after 15 days it will come.
My lords, interim order may kindly be extended.
Interim order chi.
4/7 ro interim order ta achi. Sale confirmation.
Interim order dated.
Because we are unable to finalize the sale.
But once it is added, Mr. Das, so notice has to go.
Yes, sir.
Give some time. So we are granting 15 days time. So up to that day, let us fix a date on 4th. That interim order dated so on so shall continue till next date.
My lords, I'm sorry.
Yes.
My lords, IAs that filed by us, the petitioner, seeking a direction from this honorable court for a joint inspection.
Let
That will be had.
Let my learned senior file an objection to that. That can be disposed of in the fund.
Yes, sir.
Not possible. Sale has already been.
The file has been taken by the client. Item number 23. What do you want, Mr. Das?
The file has been taken by the client. My name and as well as the.
My lord, I am
The
for
Jekera
opposite
senior
party.
advocate.
I am for opposite party number 2 to 4. That case she has already joined.
No, he is telling that his name be
Deleted
from the cause list.
along with
So,
Jekera.
if this name, two names goes, then only one names.
No, Jekera, I have engaged Jekera.
No, what about Ace Roy?
This is my associate.
Acha, then
Who
all
will
the.
represent petitioner then?
He has already taken the file. That's what I do. Transfer or challenge in the mean she has joined, but then she taken the file.
Already joined.
So I don't know.
In fact,
Let
it's not.
Let notice so.
How notice can you?
No,
Mr. Das, Land Counsel appearing for the petitioner submits that he has no instruction in the matter. The Land Counsel for the opposite parties are present. The writ petition stands dismissed for non-prosecution. Yes.
Item 22. Item 22.
Yeah.
Taken up on Friday.
All these matters, remaining
Item number 27, Your Lordship. With your due permission also, can it be taken on Monday, Your Lordship?
27.
No. Ordinarily, all these matters will come on Friday. If anyone wants the matter to be taken up on Monday, just give him a list so that it will be, right?
Supplemental list, item number 1.
The applicant convicted for the offence punishable under section 302(450) read with section 34 of the Indian Penal Code and sentencing him to undergo RI for life and to pay a fine rupees 20,000 and in default of payment of fine further to undergo RI for a period of 1 year. For the offence punishable under section 302/34 of the Indian Penal Code and to undergo RI for 5 years and to pay fine rupees 10,000 and in default of payment of fine further to undergo RI for a period of.
Why is he reading what?
302
conviction?
Yes, ma'am.
Life sentence?
Life.
So, for this,
Connecting matter.
interim application for bail and stay relation fine to be considered after receipt by the trial court. Who has filed the connected one? We are in number 746.
746, ma'am.
That has also not been admitted. The same order passport one. CR number 746, same one.
Item 2.
These are all live conviction, Mr. Huh? So it admit engage further counsel. Second one, third item, there is delay condone, admit. Four also live conviction. Same. Delay, condone, admit, and engage the council as per that list. Yes.
Item 5.
May I please? Alert, here the daughter of the convict appellant has filed an IA to release the deposited amount of rupees 1 lakh in her favor. Alert, the fact is that the convict appellant was convicted under section 302, 304, 498 of IPC Regulatory Section of the DP Act by the judgment dated 30/7/2009, and he has preferred the present appeal. Your lordship filed order dated 28/9/2011, release on bail by the order number 21, granted a bail subject to deposit of 1 lakh in the name of her daughter, and pursuant to such a direction, he has deposited that amount by way of a fixed deposit and submitted an undertaking that he has not mortgaged or pledged such amount. In the meantime, the daughter attained majority, passed +2 science, and wants to prosecute BSc nursing, and there is no other source of income. Hence, she has filed an application before the concerned trial court to release the amount in her favor. Since the present appeal is present here and in the IA, there was no direction to release the amount in favor of
The daughter has moved application.
Yes, ma'am.
No, what about the appellant?
Appellant is alive, my lord. He is on bail, my lord.
Then this is the money of the appellant. He has deposited it.
My lord, can you see the order? That is the also stated that the money deposited for the welfare of the daughter.
All right, but that should be a joint application from the father and daughter.
This application is moved by the appellant.
No.
Daughter of
No.
the appellant.
The IA has been filed by the daughter.
Yes, ma'am.
So
Then the appellant has to answer.
the appellant has to say that if
Who is appearing for appellant?
he might have an objection. You are appearing for the appellant.
No, ma'am.
Then
I am only for the daughter.
then
Who is representing appellant?
Another lawyer, my lord, filed the appeal, my lord.
have you served a copy of this application on him?
I have served copy to the state, my lord.
No,
I will
state-
serve the copy to the appellant, my lord.
Appellant
Yes, ma'am.
counsel ଆପଣଙ୍କୁ serve
Yes, my lord, I will serve the copy, my lord.
ଲେଖନ୍ତୁ IA number 1817 of 2025, an application filed by one Pratyasa Patnaik from a daughter of the appellant to pass appropriate order to release the deposited amount of rupees 1 lakh with accrued interest in her favor. The learned counsel for the petitioner submits that by order dated 28/9/2011, case number 1326 of 2009, the appellant was directed to be released on bail inter alia with condition that he shall deposit a sum of rupees 1 lakh in the name of his daughter in any nationalized bank or post office for a period of 6.5 years with renewal clause for another equivalent term, and furnish the cash certificate bracket the postal certificate or term deposit certificate before the trial court with an undertaking that he shall not mortgage or pay the same. And the learning trial court shall intimate the same to the post office or the bank as the case may be. Land counsel further submits that in pursuance of such order, the appellant deposited rupees 1 lakh and he was released from custody And at this juncture, the daughter of the appellant, who is the petitioner in this interim application, is in need of the money, as not only he has attained the age of majority and completed class 2 examination, but she is interested to prosecute her higher study in the course of BSc nursing, and she doesn't have sufficient property or source of income. And therefore, to fulfill her ambition of higher studies, the money deposited as per the order of this court dated 28/9/2011 by the appellant may be released on her favor. Stop. Let a copy of the interim application be served on the learned counsel for the appellant. The learned counsel for the state has received the copy of the interim application.
I have not received.
Also, let a copy of the interim application be also served on the learned counsel for the state, who shall obtain instructions through the concerned IAC from the appellant as to whether, if he has any objection, if the deposited amount is released in favor of the petitioner, Pratyasa Patnaik. Stop. Put up this matter in the week commencing on date on 30th of July 2024. A free copy of the order be handed over to the learning council for the state. IAC को थाना रेटा को
इटा प्रेजेंट एड्रेस मेलड आसीबो चांदपुर पुलिस स्टेशन अंडर रे नयागढ़
ना सीधा आपण रहउता आपण बापा कोड रहउछन
सेई बापा को पाखे रहउछन वर्तमान जो जगह रे रहउछन प्रेजेंट एड्रेस नु देइची एट पोस्ट पंधा नयागढ़ व्हिच इज कमिंग अंडर चांदपुर पुलिस स्टेशन
आपण जो पिटिशन लिखछन दी
मेल
सेटा लिखछन परमानेंट रेसिडेंट ऑफ सुहानसो
ऊपर रेसिडेंट ऑफ पटना के पड़ा पोस्ट डिस्ट्रिक्ट नुआपड़ा एट प्रेजेंटली रिजाइडिंग एट पोस्ट पीएस टा है छाड़ देइतले प्रेजेंट
की लिखाइन एट प्रेजेंट अच्छा
मेल
एटा होची कोन
कंध नयागढ़
कोट मिलिबो
कमिंग अंडर तो चांदपुर पुलिस स्टेशन
अच्छा ये आपण बापा भी सेट
रहउछन गोटे
अच्छा लिखिन द लैंड काउंसिल फॉर द पिटिशनर submits that the father of the appellant Sagar Patnaik is now staying with the petitioner at Kondho Nayagarh under Kou police station?
Chandpur police.
Under Chandpur police station in the district of Nayagarh.
Item 6.
What's the consent taken? The name of my landlord, Senior Mr. Anvidadas, and the assistant's name is David.
Aniruddha Das na kotibo. How can na kotibo? Tankar jeti associates. Yeah. How many appellants are there in this appeal? 2 appellants. So if you prisoner's petition aschi, दी जण देइछन ना जणे देइछ बिजनेस पिटिशन एट फ्लैग जी ये देखिए
सस्पिनी कुमार दास
बिजनेस पिटिशन जणे चिंद्रमणि तो आपण तो दी जण पई फाइल करथले ना
Consent police.
कंसेंट देइछन गाडी यू आर अपीयरिंग फॉर whom?
Indramani Hon'Ble.
अच्छा. All right. A mention is made on behalf of Mr. Aniruddha Das that since the brief has already been transferred, his name, to also the name of his associate, may not be reflected in the cause list henceforth. Stop. Prisoner's petition has been received from appellant number 1, Indra Mani Sundarai. Inda alias Indra Mani Sundarai alias Chand Khan, for engagement as a prisoner's petitioner, Jiraj, for engagement of Ashwini Kumar Das as his advocate. And Mr. Das has Mr. Das has already filed Wakalatnama for appellant number 1, which is accepted. আপনার না কজ লিস্টে আসছি না আসিনি আজই তো ঠিক আছে what do you want further, madam?
My lord, IA has been filed for bail.
You have filed the bail application.
My lord.
20 देखिए
Custody period.
IA 1219.
Custody period how much?
My lord,
Custody period of custody.
custody, it's about 17 years, but date of custody, date of custody.
What is your information? The IA number so and so, this is an application for bail of appellant number 1, Inda alias so and so.
Only one of them.
ନାଇଁ ଏଥିରେ ଆପଣଙ୍କର କ୍ରିମିନାଲ ଅପିଲଟା ହଉଛି 2 ଜଣ ଫାଇଲ କରୁଛନ୍ତି, ଯିଏ ଆପିୟର କରୁଛନ୍ତି ଆପେଲାଣ୍ଟ ନମ୍ବର 1 ପାଇଁ, ତ ଆପେଲାଣ୍ଟ ନମ୍ବର 2 ପାଇଁ ଯିଏ ରହିଛନ୍ତି ସିଏ ରହିବେ, ଫରଜ ଆପେଲାଣ୍ଟ ନମ୍ବର 1 ପାଇଁ ଇଏ ରହିବେ, ତେଣୁ ସେଇ ଯୋଉ ବେଲ ଆପ୍ଲିକେସନଟା ଫାଇଲ ହେଇଛି, it is filed for appellant number 1. You see that Inda alias Indramani is the petition, right? In the interim application, it has been mentioned that the petitioner is in judicial custody for more than 17 years and he has got no criminal antecedent. Paragraph 5 re mention karchandi.
That accused already has.
All right, let that instruction come. Let the Land Council for the state obtain instruction in this aspect, on this aspect, and produce the custody certificate and also written instruction relating to the criminal antecedent, if any, against the petitioner. Put up this matter in the week commencing from 28th July 2025.
Item 7.
Last of it, no director state council to bring the custody certificate out of the criminal accident.
Got the
My.
You have not filed the surrender certificate.
So difficult.
Then how can we know that you are in custody now?
Now he's in
You
custody.
are released on bail, interim bail,
But now
as per order dated.
But initially he was in Dhenkanal jail. Now he has been transferred to Kuntoni jail. So it's difficult to nobody there to apply me that certificate.
ଆପଣଙ୍କୁ ଆମେ ବେଲ୍ ଦେଇଥିଲୁ 21/10/2024 ରେ ଏବଂ 3 ମାସ ପାଇଁ ବେଲ୍ ଦିଆଗଲା, ଇଣ୍ଟରିମ୍ ବେଲ୍। ତ ତାପରେ ଆପଣ ସିନା ସରେଣ୍ଡର କଲେ, ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ଦେଲେ ଆମେ ଏଇ ବେଲ୍ ଟାକୁ ଏଣ୍ଟରଟେନ୍ କରିବୁ। ହାଉ କ୍ୟାନ୍ वी नो if you are not producing, then we have to call for a report from the Land and Trial Court.
Well, that is the lordship called for the.
Any instruction you have received that he has surrendered?
now can find tomorrow.
Good, good.
When we
Received, हाँ ठीक है। तो केते पीरियड आସୁଛି ନା?
13 ବର୍ଷ।
अच्छा, नो एडवर्स देखो तो लगन IN number 132 of 2025 is an application for bail. The petitioner was directed to be released on bail, interim bail, for a period of 3 months. in IA number 97 of 2024 as per order dated 21/10/2024. Taking into account the period of detention in judicial custody, as well as the ratio laid down in the case of Letty alias Joydev Rai and another versus state reported in so and so. As per our previous orders, the Land Council for the state has produced the custody certificate, which shows that the petitioner is in judicial custody for more than 13 years. He has also produced a written instruction that the petitioner has surrendered and is now confined in model convict prison at Gad, and there is no adverse report against him, and his conducted behavior during the stay in the jail is satisfactory. The reports produced by the Land Council for the state are taken on record. Keeping in view the period of detention of the petitioner in judicial custody, and since the petitioner has not flouted the terms and condition of the interim bail order, and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
Item 8.
May I please? Military appellant is convicted for the offense 302 of IPC and sentenced to undergo for life imprisonment. And he is inside the jail custody since 13/1/2011.
Have you got that custody certificate? Where is your IA?
38 for stay and 39 of 2023 for
Alright,
bail.
there is an application for bail wherein it is stated that the petitioner is languishing in jail custody since 13/1/2011. Let the Land Council for the state produce the custody certificate and also obtain instruction regarding the criminal antecedent, if any, against the petitioner. So also the conduct of the petitioner in jail. Put up this matter in the commencement from 28th of July 2020. Other would I stay realization of fines it allowed for them. That stay has not been granted as yet.
No, he has been.
No, not granted. So stay realization of fine.
Item 9.
You'll also have earlier asked me to local PVT. 16 years, more than 16 years custody is an outside.
You said that you are ready for
Merit. You also kindly put up in the hearing list day after any day from the hearing list. So that
since this is a jail criminal appeal of the year 2017, and the petitioner appellant has remained in judicial custody. What is the period of custody?
more than 16 years. Can you see custody certificate there in the period? 16/11/2024, 15 years, 9 months.
ground realities are different.
Yes, sir.
That's the problem. Otherwise,
Because your lordship is hearing the matter of 2004, 2005 in the list. The 2017 lord, I don't feel that if your lordship will not direct in the matter benefits.
No, it's shown.
So your lordship can fix a particular time, my lord. I'll take half an hour, not maximum in this. It's a single blow.
There are eyewitness to the occurrence.
Yes.
The appellant first stabbed another person with a knife, then stabbed the deceased, your lordship. Why was she
No
died?
intention, my lord. He come down from a train. And you are rushed to the curfew and stabbed it. Like you have of 11 years.
He got four.
Single.
304 part 2 you want?
Yes.
Part 1, sorry. Part 16 already under compulsory. Let him argue the appeal because
Any day, the lordship may post it to any day.
Submit that the petitioner that the appellant is in judicial custody for about 16 years. And since paper books have already been prepared, the matter may be added to the hearing list. Ms. Subalakshmi Devi, Land Counsel, appearing for the state, has no objection to the same.
Yes.
And she has also received the paper book. The matter will be stayed for hearing on 23rd July 2025.
Item 10.
पत्नी कस्टडी 12/8/2010 13 वर्ष 11 मास कस्टडी रही.
How many appellants are there?
2 appellants are there.
Okay, one is Punia alias Manoranjan Mahapatra, the other is Babun alias Akshay Mahapatra. So have you been released, any of the appellants have been released on bail?
Punya alias Manoranjan Mahapatra.
Punia has been released on bail. So A1 kebe bail level.
No, madam. Interim bail le jayega. Appeal for appellant 1, madam.
So you are for appellant number 1. Appellant number 2 pai ki achen?
There are 2 bail applications, my lord. I think there are 2 bail applications pending.
ସେଇଆ ହିଁ ଦେଖି ପଚାରୁଛି ଆପଣଙ୍କର ଗୋଟେ ହଉଛି IN number 806 of 2018. This is filed for appellant number 1. Then another IA also filed for appellant number 1. Then the third IA is filed for early hearing. So one application is to be not pressed. So which application you have filed for the appellant number 1?
IA number 457/2025.
457 of 25. So this is an application for early hearing of the bail application.
Yes.
We are hearing you today. We are hearing you argue the matter, but you should not press one of your interim application, because both the interim application are for bail of appellant number 1.
you have moved 2 applications for bail, 1 application for early hearing of the bail application.
ଶୁଣୁଛୁ ଆମେ ଆଜି ତ ଶୁଣୁଛୁ ତେଣୁ say that application.
All the 3 applications will hear it today.
So please tell that one of the application you are to not press it. So that 2018 application we are not pressing. You not press it and move this 457 of 25. That is the latest one you have filed. 1980 of 25, right? So how many years you are in custody?
13 वर्ष 11. 12/8/2010 ରେ custody.
That certificate is there.
Get it.
Trial court record ରୁ ଆମେ ଦେଖିପାରିବୁ at least କୋଉ ଡେଟ୍ ରେ ସେ କଷ୍ଟଡି କି ଗଲେ ଫାଇନାଲ ଫର୍ମ ରେ ଏବଂ ଅର୍ଡର ସିଟ୍ ରୁ ଜଣା ପଡିବ ସେ ବେଲ୍ ଯାଇଛନ୍ତି କି ନାହିଁ. ବଟ୍ ୱାନ୍ସ ଦି କନଭିକ୍ସନ ହେଲା ପରେ ଆମେ ଯଦିଓ ବି ବେଲ୍ ଯାଇନୁ, ବଟ୍ ଏଇ ଯୋଉ କୋଭିଡ ପିରିୟଡ ରେ ବହୁତ ଜଣକୁ ପ୍ୟାରୋଲ ରେ ଛଡା ହଉଥିଲା ତ ସେଗୁଡାକ ଏକ୍ସକ୍ଲୁଡ କରି ଆପଣ ନେଇ ଆସନ୍ତୁ.
Do you have custody certificate? Do you have with you?
No custody certificate.
No, we do not know. Why are you not applying? That's that has been passed that even if a convict also applies for the same, the concerned jail superintendent has to furnish it. It is not necessary that it will only to be given to the state council. Any appellant can also get it. So, all right, lekhun. We are asking the DG of Prisons to upload the custody certificate of all the convicts. Okay, and furnish that website so that we can also.
So what is happening is we are wasting time in the hearing. If it is uploaded, we can very well see, or anybody can take out the printout, and a lot of your saved time is saved, our time is saved.
All right, take down. कौन लिख ले? आइए तो not press कर दो.
Every month end, they should upload it.
IA number 457 of 2025. This is an application for early hearing of the bail application. Since we are hearing the bail application by IA number 1980 of 2024, no further order is required to be passed in this IA. Accordingly, this IA is also disposed of. है ना? तापर लिखा हूँ IN number 1980 of 2024. There is an application for bail to land counsel for the appellant. Number 1 submits that the appellant number 1 का नाम Punia alias Manoranjan Mahapatra is in judicial custody for
How many years, according to you?
More than 13 years. In most of the cases, particularly in old appeals, where bail application are filed for release of the convicts on bail, we find and a submission is made about the period of detention of the convicts appellant. We used to ask the State Council to produce the custody certificate to know the period of detention of the convict stop, and this in turn delays the disposal of the bail application. Therefore, let a website be created by the DG of Prisons in which the custody certificate of all the convicts staying lodged in different jails of Odisha be uploaded, and it should be time to time. The data may be updated time to time relating to the period of custody, so that it would not delay the disposal of the bail application. Stop. Let a copy of this order be handed over to the Land and Council for the state. Will communicate the same to the DG of Prisons. Simultaneously, the file be placed before the registered judicial court. We will also communicate this order to the DG of Police. Put up this matter in the week commencing from 28th of July 2025. The Land Council for the state shall produce the custody certificate and also obtain the instruction regarding the criminal antecedent, if any, against the appellant number 1, and also apprise this court about the progress of creation of the website relating uploading the detention data of the different convicts throughout the Orissa.
This case, my lord, they have released and bail on 8 to 24 for a period of 60 days. 8 weeks. Both the appellants, whether they are surrender or not,
Surrender.
personally.
Surrender.
During that period, they have committed in time.
अच्छा वो period दिया इतना
Order dated 8 to 24.
It appears from the order dated 8 to 2024 that both the appellants were directed to be released on bail,
For a period
interim bail, for a
8 weeks.
period of कितने दिन जाइए
8 weeks.
पूर्ण लिखा है
मतलब paragraph 5. 10.
for a period of 8 weeks. Land Council for the appellant submit that after availing such interim bail period, the appellants have surrendered at right time. Stop. The Land Council for the state shall also obtain instruction regarding the conduct of the petitioner while on interim bail. Copy of the order again.
Item 11.
आइए 545 पर फेल नहीं है लास्ट petition मैंने डायरेक्ट इंट्रीम में प्लीज माय कॉन्ट्रैक्ट
By order say 9/4/25, you will also the directed to obtain the report as to conduct as well as the custody action. There is a communication gap between my office.
You want some more time? Keep it up.
Next week.
All right. Suvalakshmi Devi Land Council appearing for the state seek some more time to obtain necessary instruction as per the order dated 9/4/2025. Put up this matter on 23 तारीख रख ले चलेगा बुधवार 25th of July.
Item 12.
Final argument for bail of appellant number 3. It is a flat B, file number 722 of 2045. Now let's make this annexed case where the letter has come with regard to the special campaign of the old prisoners and terminally ill case. The present appellant is 75-year-old man. He is suffering from
Terminal illness.
he is suffering from an illness called eczematous ulcers, which has spread all over his body. That is just a prescription by the medical officer. That has to be through a format by in terms of the NATSA campaign. I have to take.
But are you disputing about age 75?
Instruction.
Either or,
Either or, na?
No, it is
75.
not 75 years.
26.
So take instruction about the age.
From the jail. The report is from the jail medical officer. That
is all right, but the question is that particular disease has to come it is a terminal illness. So what is that disease, as you said?
Eczematous ulcers, which have spread all over his body, and if proper infection and management cannot be done, it can be terminal.
It can be. It can be converted to terminal. But your case is covered under the first clause, that is 75 years.
Like on IN number 722 of 2025, there is an application for bail of appellant number 3, Udayanath Naik. Ground has been taken in the interim application that the petitioner is 76 years old, and in view of the special campaign for release of for release on bail of old prisoners and terminally ill prisoners, the bail application of the petitioner maybe to be favorably considered. And counsel for the state submits that he has received the copy of the interim application and seeks some time to obtain instruction, particularly with reference to the age of the petitioner,
Age and the genuineness of the.
as well as the medical jail doctor
Particular disease.
whether the disease which the petitioner is suffering from comes under the definition of terminal illness or not. Put of this matter on 25 तारीख रखुछु.
Yes.
Yes.
Item 13.
In this case, my lord, petitioner challenged the order dated 14/9/2020, my lord, passed by the learned additional session judge, Rayanpur. My lord, in this case, my lord, there is no eyewitness basing upon the circumstances of evidence, my lord.
Are you arguing the appeal or
appeal, my
bail
lord?
appeal?
No, bail appeal, my lord.
What are you arguing?
BL appeal.
No, ठीक है. आपनकर prisoners petition
आगे मतलब
केतेटा prisoners petition आज आइछि. ओते आसला ओटा किछ consider any or 3C are how many appellants are there?
2 appellants are there. Yes.
Prisoners petition dated 3C are 2022 received for engagement of so and so. Then out आसला 22/4 30/6 तापर आसला 7/9/2023
ना तो 25/1/2024
25 के
2024 जी
25/7/2024 and that is the latest one at flat K এটা ভার করলাম এটা নতুন কেউ বলুন কি এটা হচ্ছে
Requesting to engage Sapan Kumar Pal.
गुरुचरण कारुआ.
Yes, Allah.
गुरुचरण कारुआ कितने नंबर appellant?
2 number.
2 number.
Yes, Allah.
So say that request has been made by him for engagement of you, right? So you have filed your Vinama.
Yes, my lord. I filed.
वकालत नंबर देखिए. এবার লেখা হয়েছে স্বপন কুমার পাল এন্ড অ্যাসোসিয়েটস ফাইল ওকালত নামা বলি লেখা হয়েছে কজ লিস্টে লেখা হয়েছে এই ওকালত নামা Petition 25/7/2024 at flag K, Varkonzera, flag K, no? In which prayer has been made. Prisoner's petition of appellant number 2, Guru Charan Karwa, for engagement of Mr. Sapan Kumar Pal as his advocate. Mr. Pal has filed a wakalatnama, which is accepted. So, who will application to file person appellant number 1?
Dita sir, Dijon ko pa sir mo Dijon ko pa appear each means.
1313, it is for appellant number 2.
Yes.
And IA number 1312
is appellant number 1, my lord.
You are appearing also for appellant number 1.
Yes, my lord.
It's all right. So whether the bail application was earlier rejected.
Interim bail pass appellant number 1.
13/5/24 he was allowed on
Already surrender in time, my lord. Surrender certificate is in the my lord.
For what period you were released on bail?
3 months.
That to be released
Till 19th June 20. Thereafter you have surrendered.
Yes, my lord. Immediately I have surrendered.
Almost a month.
Interim bail, madam.
So who has granted bail? Appellant number 1 only.
Only appellant number 1, my lord. Number 2, my lord, not released till arrest, my lord.
But in that very order,
yes, my lord.
13/5/2024, it has been mentioned in paragraph number 4 that while being not inclined to release appellant number 1 on bail on merit.
Yes.
So that means so far as 1 is concerned, merit it has been rejected. Appellant number 2 pai kisi semti order nahi. So why don't you argue for appellant number 2? Let us see that if you can. Appellant number 2 ro jo bail application achi 1313. This appellant is Guru Charan Karwa. And how many years you were in custody?
8 years.
2017 you were taken
Yes.
into custody. Okay. So what is the allegation against you?
Basing upon the conferential statement, my lord,
no eyewitnesses.
No eyewitnesses is there.
3 person has been killed, 2 minor children, 1 lady.
Lady.
The
But
mother.
3 accused person also registered this case against the name of the, but one accused already released acquittal in this case, my lord. After so many years abscond, he come and my lord kindly.
No, it's a case of triple murder.
Yes.
Right. So and prevention of witch hunting act.
Which, yes, my lord.
So now on what ground you will be granted bail? What is the materials?
Well, there is not concrete evidence against the.
What are the circumstances cited against you?
Yes, my lord. Only basing upon the PW8, PW17, the executive magistrate. They are confessed the executive magistrate. They are doing such offence, but they are not doing such offence. My lord, I have produced one judgment.
Yes, just a minute.
PW8 is an informant who says the accused person went to the deceased and threatened her to kill. That is one circumstance. And thereafter, the entire while she was going to her in-laws' house, she, along with her 2 children, were killed. And the dead body and the weapon of offence are recovered at the instance of the
At the instance of the
accused persons. And the appellant number 2 is the person, according to whom the section 27 discovery as to weapon of offence has been discovered. There is a exhibit PW number 17 is the Tahsil that executive magistrate.
Confession.
And there is a confession by both the appellants. That is the entire circumstance.
Who is that executive magistrate?
Exhibit
PW 18.
17.
17.
May I
There are
please
two
be-
circumstances according to you. One is 27, second is confession.
Confession and the motive by PW8. So they have threatened. They were,
No, that confession was made in police station.
Yes.
And so then, of course, the accused persons led the police party and
yes, sir.
showed the dead body of that deceased lady and gave recovery of the weapon of
Weapon
offense.
of offense.
So this much is relevant,
Yes, sir.
that confession. But it's a case of triple murder. Why
Triple.
the granted bail, similarly situated man's bail application has been rejected
Rejected or
and
let him wait up.
just
My lord,
put up this matter
my
after.
lord, my humble submission.
Come after
Three-
vacation.
Three persons are accused in this case, my lord.
One of them is acquitted.
One person already acquitted in this case by the trial court, my lord. This is the
Next,
basing upon the same.
next item.
Item 14.
Yes, item 14,
Yes, my lord.
appellant number 1. You are moving appellant number 1's bail application.
Mine will be deleted because
अच्छा, since C Kosturi को वकालत नोट देखिए
last time order
हाँ
last date order 16.
ये जी
On president speaking.
हाँ accept तो ये अच्छा the name of Mr. B.V. Raut and his associate shall not be reflected in the cause list. Okay. अच्छा so there are two bail applications for the same appellant.
Mine is my lord. My bail application, my lord.
1617.
17/25, my lord.
That is for appellant number 1.
Yes, my lord. Appellate number 1, my lord.
But just a minute. 446 was the appellant number 1 is Nupati Behra.
Yes, my lord.
So another application is pending.
No,
That is
that is not mine, my lord.
ଆପଣ ନାଇଁ ଯେ ତାକୁ ନଟ୍ ପ୍ରେସ୍ ନ କଲେ ଆପଣ ମୁଭ୍ କେମିତି କରିବେ? ଆପଣ କଣ ଦିଟା ଆପ୍ଲିକେସନ ଆ ଦେହରେ ରିଜେକ୍ଟ କରିଦେବୁ ତା ଦେହରେ ବେଲ୍ ଦେଇଦେବୁ ଏମିତି ହବ କି? ତ ଗୋଟାକୁ ନଟ୍ ପ୍ରେସ୍ ଆପଣଙ୍କୁ କରିବାକୁ ପଡିବ. Since you are now the counsel,
Yes.
you have to not press the first one and you have to move the bail application which you have filed.
Yes, my lord.
Right? ସେଇଆ ତ ଆମେ କହୁଛୁ. ଦେଖନ୍ତୁ IN number 446 of 23. This is an application for bail of appellant number 1, Nupati Behra. The C Kosturi Land Council appearing for appellant number 1 submits that since she has filed a fresh bail application for appellant number 1, she does not want to press this interim application. Stop. Accordingly, IA number 446 of 2020 is disposed of as not pressed. বর্তমান মুভ করুন
The IA copy may be sought upon.
কোটা কোটা
The 1617, that copy has not been sought.
Yes, I have.
Comparing to,
ডিপোজিশন কপিজ
no, the IA copy.
ও আইএ কপিটা দেই না দি প্লিজ হ্যান্ড ইট ওভার let a copy of the interim application IA number so and so is an application for bail. What is the custody period?
That's what people, I don't have also deposition copies only that I have.
No, see,
Interim application copy
Very cheap.
ହିଁ ଗୋଟେ କପି ଦେଇ ଦିଅନ୍ତୁ କଣ
Already paper book ହେଇଗଲାଣି madam.
they do not want any deposition copies because paper book has been prepared and they are having that. They just want your interim application copy for bail. So pass it on. What is the period of detention?
It's all right, madam. Give one more copy.
What is the period of detention?
My lord. 8th year commencing, my lord. 7 years.
So you obtain the also after receiving that IA, you receive the custody certificate also. Like on the Land and Council for the appellant number 1 submit that appellant number 1 is in judicial custody for more than 8 years. The let a copy of the interim application be served on the Land Council for the state will obtain instruction, produce the custody certificate and also obtain instruction regarding criminal antecedent, if any, against the appellant number 1. Put up this matter is will commencing from 28th of July 2025.
Item 15.
May I present?
We're under POCSO.
So,
Notice has to go to the.
What is just
because due to the fault of my step, This matter has been taken up in 2023. He has been granted interim bail. Nobody has pointed that.
IN number so and so, this is an application for bail. Kiye diga jai bail.
No, one jaitala interim bail, he has surrendered in time.
Okay, now you have filed the interim that
Entire bail application for the two.
two actually. Click on it. IN number 2103 of 2024. There is an application for bail. Mr. Das, Land Council submits that appellant number ki jaitala bail?
One.
Appellant number 1, Prithviraj Pradhan, has been directed to be released on bail by this court as per order dated 18/3/2024 for a period of
1 month.
Huh?
1 month.
1 month.
17/5.
Acha. For a period of about 1 month କେମିତି ହବ? 17/18/3 ने order ଟା ହେଲା 17/5 ପର୍ଯ୍ୟନ୍ତ ପାଖାପାଖି 2 ମାସ for a period of about 2 months, and after availing the same he has surrendered at right time. The Land Council for the state shall produce the custody certificate of both the appellants and also
reflected in the judgment also.
And also obtain instruction regarding the conduct of the appellant number 1 while on interim bail. Matter.
On notice to the implement.
Acha. Since one of the offense under which the appellants have been found guilty is section 6 of the POCSO Act, the Land Council for the state
Item 16.
No, on behalf of Mr. Chan, my lord, may I submit?
How many appellants are there?
No, 5.
You have filed this bail application for all the
5.
All the 5. So how many years you are in custody?
My lord, from 16 to 2023, my lord, after this judgment, my lord. During the
Prior to that you are on bail.
my lord.
So have you supplied the deposition copies?
Paper book has
The paper book is there. Your bail application was never rejected?
My lord, once rejected on 3/9/2024,
then
not inclined to accept the at this particular point, my lord.
Taking into account the submission made by the government want to eyewitnesses for the taking of the incident took place after. So merited reject he possibly in.
But my lord, may I place, my lord, because there is no weapon used by the anybody, my lord.
Again on merit.
There are high witness.
We can't consider merited.
Because may I only place the doctor report, my lord.
No, whatever it may be, merit once it has been rejected and there is 1 year has not passed, we cannot differ from the view of one of the brother judges.
And
Custody period is just 22 वर्ष भी है नहीं. And we are just adjourning the matter. This matter after Durga Puja vacation. Yes, next.
Item 17.
Sir, 1 week after I will supply the disposition. Mr. Land Council for the appellant submits that he will supply the deposition copies of all the witnesses examined in the trial court to the Land Council for the state during course of this week.
Yes.
Or by next week.
Next week.
By next week. Because this matter will be commencing from 28th July 2025. Yes.
Permitted to take the disposition copy.
Permitted
to take the disposition copy.
ये soft copy of yes soft copy. Land council for the कहीं देवे सीवी तो नहीं जीवे और कौन ये जो काटी जाए. The land and council for the appellant, so also the land council for the state submit that they are not having the deposition copies with them, and they may be permitted to take the copies of the deposition in their respective pen drives from the soft copy of the trial court record. Let the registry do the needful and permit the petitioners or the appellants to take the deposition copies in their respective pen drives. Matter will be listed in the week commencing from 28 July 2025. Give it during course of the day, otherwise
Yes.
once this goes means it will be difficult.
Yes, I'll try.
Yeah.
Item 18. My lord, we are bail.
Yeah. Your sister's name is still there as in name. She is now in state panel. So her name is to be deleted here. Right? You have to say that. Like, Miss Binapani Tripathi submits that since Vijayalakshmi Tripathi is now in state panel, her name may be deleted from the cause list. Let the name of Vijayalakshmi Tripathi be not reflected in the cause list. Yes, Pund.
My lord, prayer for bail. Offense committed 302-34-449 of IPC. 1 and 3, my lord. Appellant number 1 and 3, Dilli Das and Sudhir Das. Date of occurrence 34-2000.
Just a minute, madam.
Appellant number 2 is on bail.
Appellant number 2 is on the bail 9/5/2025.
Wait.
No answer. My lord, custody freedom of
ठीक है रूम तो ठीक है धैर्य धरो तुम व्यस्त लो. So we took into account the period of detention of that appellant number 2 and that he had not misutilized the liberty. That is how we granted him interim bail for a period of 3 months. So now you are moving this bail application for whom?
My lord, 1 and 3. এটা ଅଲଗା ବେଞ୍ଚ ଥିଲା ଆପଣଙ୍କର ଏସକେ ସାହୁ ଆଉ ଆରକେ ପଟ୍ଟନାୟକ ଏଠି ଥିଲା ଡି ଦାସ ଆଉ ଭି ନରସିଂହ.
Why are you mentioning the names and all? What is the necessity?
We are asking you that who has been granted bail and whose bail application you have filed.
My lord, before 3 months interim period right time ରେ surrender କରିଛି.
ଏ appellants ମାନେ ଆଗରୁ bail ଯାଇଥିଲେ?
3 months ଯାଇଥିଲେ.
କୋଉ order ରେ?
Which order?
27/2/2024 interim bail ରେ 3/4/2024 ରେ surrender କଲେ.
So what is their conduct? Have you obtained instruction?
Yes, sir. My lord, period of cost 8 years 2 months.
ଆମେ କଣ ପଚାରିଲୁ ତାଙ୍କୁ?
Sir.
Yes,
I'll take an instruction.
take. ଲେଖନ୍ତୁ IN number 1467 of 24. This is an application for bail filed by appellant number 1 Dilli Das and appellant number 3 Sudhir Das. Ms. Tripathi London Council appearing for the petitioners submitted that both the petitioners were directed to be released on bail, interim bail, for a period of 12 weeks. As per order dated 27/2/2024, and after availing the same, they surrender at right time. She further submitted that the petitioners have remained in judicial custody for more than 8 years. The Land and Council for the state seeks some time to produce the custody certificate.
My lord, there.
Yes. The land counsel for the petitioners have produced the custody certificate which are taken on record. See the phone and the UR. Afterwards, for, so it can call it available. Land counsel for the state seeks some time to obtain instruction regarding the conduct of the petitioners while on interim bail as per the order dated 27 to 2024 and also their conduct in jail. Put up this matter will be commencing from 28th July 2025. Yes.
Obliged.
Item 19.
My lord, I am here to take this matter next week.
Next week.
Yes, my lord.
Right. Mention is made on behalf of Suryakant Dwivedi, Nathan Council for non-assent. For adjournment, place this matter. We commencing from 21st July 2025. Yes.
Item 20.
Item 29, please, your lordship.
Yeah.
My lord, today I am moving that IA number 13 of 25 for consideration of bail application. That appellant in custody for more than 7 years. As for last order, my lord calls for the custody certificate that is on the record. My lord, the
custody certificate.
Black
C.
My lord, last day.
Yes, Tom. 7 ବର୍ଷ 7 ମାସ এটা হচ্ছে 5 ମସିହାରେ ମାନେ ଆଉ 2 ମାସ ଯାଇଥିବ 7 ବର୍ଷ 9 ମାସ ଠିକ ଅଛି ତାପରେ ଆଉ କଣ କହିଥିଲ ଆଉ ଗୋଟା ଆଣିବ କଣ criminal antecedent
Recorded. It was also recorded.
ଅଛି
Yes.
କାଇଁ
Flat fee.
Black ରେ custody certificate ଅଛି conduct ଟା ବି ଅଛି ସେଥିରେ ଏ ସେ ଯୋଉ ଇଏ criminal antecedent custody certificate is there, don't worry about that, but we want the inspection regarding criminal antecedent. So and so he was involved in GU further as per the case record.
There's a flag C on.
Acha, PS number. It revealed that which was of it was sale of antecedent. Buttu, house, Buttu man to say, oh, yeah. Amruta Naik,
Amrutalam Naik.
You have been found guilty in one case and
1, 2, 3. One
author of G Udayagiri case number, author of 2021.
Another case number 92 of 2017. And he has been convicted in G Udayagiri case number
92 of 2017, 2 year sentence.
এই কেসটা হচ্ছে 18/2011 পিএস কেস জজমেন্ট উপরে দেখুন জজমেন্টরে লেখা হইদিব ঠিক তলে কেস নম্বর দিয়ে পড়তো লেখা হইদিব
In PS case number 92 of 17 he was convicted.
92 টা এইটা
PS case number 92 of 17
that he served 2 years.
No, 92 টা হচ্ছে এটা এই জজমেন্ট
present appeal.
This is relating to the 92 of 2017.
Right.
Another case is G Udayagiri case number 18 of 2011, in which he has been convicted.
No, we do not know that what is the offense there.
The report is very vague.
I'll take
Get a proper report.
Yes, sir.
Though the report relating to the criminal antecedent has been submitted, report relating to the criminal antecedent of appellant number 1, Uttu alias Amrutalal Naik has been submitted by the IIC G Udayagiri police station, but it appears to be vague and doesn't indicate as to whether in G Udayagiri PS case number 18 of 2011, the petitioner has been convicted, and if so, what was the sentence imposed? Or like the status of G Udayagiri PS case number 18 of 2011. Dita case mention is madam.
Yes, sir.
Gote hochi 92 of 2017 jota ki present case.
Present case.
Au gote hochi 18 of 2011 जोटा की offence देखो जी 341
7 notes.
307 506 by 34. So you are to obtain the instruction about the status of that case.
18 of 2000.
हाँ, लेकिन status of उदयगिरी PS case number 18 dated 28/2/2011 है ना, under section 341 307 506 by 34 of the IPC. Yes. Obliged. Yeah, please take the next one. Obliged.
21.
Yes, Mr. Tripathi.
On the last occasion, your lordship was pleased to heard this matter extensively. Now, this is a matter, there are two connected appeals. Now, the father and the son is before your lordship for commission of offence under section 302. CRLA 450 is the father.
Is it been rejected earlier on merit?
No, this is for the first time.
First time. Have you received the deposition copies, etc.?
It is the next month.
How many years the appellants are in custody? You said two appellants in two separate criminal appeals. These two persons only were facing trial or somebody else?
These two persons.
Okay. What is the prosecution case?
The prosecution case is.
You come to paragraph number 2 of the judgment.
2 months. May I place?
Yes.
Well, prosecution story in nutshell is that on 11/8/2022 at about 11:25 AM, while the father of the informant had been to market to sell some articles at that time, taking previous enmity, the accused persons assaulted his father by means of wooden plank and scissors, for which the deceased sustained bleeding injuries on his person. Hearing this, the informant reached at the spot and took the deceased to medical, but doctor declared him dead. Thereafter, the informant lodged the report at Purnagata police.
So it appears from the judgment, paragraph number 5, that PW 5, 16 and 17 are eyewitnesses. And PW 18 is the doctor who conducted TN. So let us go.
7 and 8. On their presence, the weapon of offense was seized.
Achha. PW 7 and 8 seizure of weapon of offense. Okay. Now you come to PW 5. A trial court record of argument. PW 5. Please place it.
I know the informant, deceased, and the accused person standing in the dock. The occurrence took place on 11/8/2022 at Lunibahal Chowk about 10 AM. On that day, I had been to market to purchase vegetables and found on the way accused persons and deceased were quarreling with each other. I saw Asif Bari assaulted deceased by inflicting assault by means of wooden plank.
Asif Bari mane ki hai?
The son man. Unconnected. Getting such assault, the deceased fell down on the ground. Asif Bari thereafter caught hold of the deceased, and Subhas Bari, the father, started inflicting assault on his person by means of scissors. Both of the accused also threatened to kill if any other person come to the spot. On the way, I met Subrat Bari and narrated the incident to him. I also intimated others. My family members came to the spot. Then I was examined by police on the next.
No, it's all right. Come to the PM doc. The doctor, PW8. So the number of wounds are there which can be caused by that seizure. Caught multiple stab injuries. These are the two injuries which are number 6 and 7 that may be possible by that appellant in Asif.
And the CRLA 220 of 2020.
And he has stated also that it can be caused by blunt and so on. So, but injuries are fatal because these two injuries are on head. One is on the left parietal bone, the other is over the frontal bone.
Your Lordship, kindly consider
that the witness PW5 my lord, he specifically mentioning that wooden plank injury was on the neck my lord, not on the head my lord. It was on the neck. And subsequently the eyewitness to the occurrence 16 and 17, lord, they are silent about any action or any role played by the petitioner, the appellant in CRL number 220, 2024. Subhas, Asit my lord. Asit my lord. The son only my lord, has been implicated for inflicting injury on the neck my lord.
No, ଅସିତ ହଉଛି ପ୍ରଥମେ ମାରଲା
wooden plank.
wooden plank ତାପରେ ଯେତିକି assault ସବୁ ଗୁଡାକ ବାପା ମାରିଛି ସୁବାସ by seizure. So ଏମାନେ ହୁଏତ ସେ assault ଟା ପାସ୍ ହେଲା ପରେ ଆସିଥିବେ କି କୋଉଠି PW ଯୋଉ 15 and 16 and 17. 16 କଣ କହୁଛି କଣ simultaneously ଥିଲା beginning ରୁ ଥିଲା
16 and 16 କହୁଛୁ ଯେ
So he was not present from the very beginning.
Somebody told him.
Somebody told and he came and then he found that.
Let me explain the entire incident in this way, man.
No, that is explainable. That is.
Only one point I would like to explain, man. The first incident was witnessed by witness number 5, man, who in his statement categorically is mentioning that in his chief itself, in the fourth line from the top, my lord, in his examination in chief, that to purchase vegetable and I found on the way accused persons and the deceased were quarreling with each other, my lord. So there was a tussle, my lord, going on, and I saw Asit Barik assaulted deceased by inflicting assault by means of a wooden plank on his neck, my lord. It means that the wooden plank, immediately it has been stated that wooden plank was, my lord, it was not premeditated. He lifted the wooden plank, my lord, which was very much present at the spot of occurrence, my lord.
Where from you got that?
Lord,
it was lying in the spot.
My lord, it is
Picked
there,
up.
my lord.
It was caused.
My lord, it has been stated, my lord.
Yes, para 4. Come to para 4.
Para 4.
Para 4, read between.
My lord. In between, I saw the accused Asit Barik took the meda which was lying nearby and inflicted.
I saw the accused Barik took the meda which was lying nearby and inflicted the assault.
My lord. About. In the last, it has been mentioned after deceased fell down, the accused Subhas, the father started inflicting assault by means of
Subhas was holding that seizure.
Seizures.
That has come.
And these two persons arrived at the scene of the occurrence when the assault by Subhas was going on.
At 10:30, your lordship is the first person, my lord, your lordship is correct, was very much present at 10 a.m. And subsequently around 10:30 they came.
So PW5 is the only eyewitness.
So for the assault on this,
I think the eyewitness from the very beginning.
for the both the assault, but this 16 and 17.
They came later on.
Yeah.
Heard it and came.
They saw the assault by that Subhas. Seizure group.
We can think of.
Sudden provocation. What is the that man Asit? What do you say?
See, for Asit, there are two very apparent things. One is the quarrel was going on.
Yes.
And in the fit of race, something was lying, he picked up and gave the blow.
Now,
That's not premeditated. He was not possessing any weapon. It was only picked up and given a blow.
my lord,
Yes.
that is there, my lord. The Freedom 5 is saying that on the spot he picked up a medal and assaulted, my lord. My lord, the petitioner has very much intention to kill my lord, because he would have assaulted the deceased at any other place, but he assaulted on his head.
That's also doubtful. Neck and head.
Head.
He said neck.
But
The
injury,
corresponding injury is at head.
Head.
That's also bit.
there is no other person intervention is also there. Only it may be neck or it may be head, but his intention is to kill the deceased man. That's why
There was no fracture injury on this skull. The autopsy, they found that the skull was intact. And it was actually the internal hemorrhage. That is how the blow was not with such force.
only the laceration.
That was laceration was caused, but there was no fracture of the skull bone.
Right.
So that shows that the impact of that blow, which was given on the head, was not. And his case is distinguishable from the other person's case, who was given multiple stab injuries and cut injuries on different parts of the
Subhas doesn't have a case because he was possessing the seizure.
seizures.
Intention was there.
The outside I was
Any,
about to
what about the criminal antecedent?
There is no criminal antecedent.
And what is the period of detention of the suspect?
2020. Page 9, page 10 of my judgment, of my petition.
Page 10 of your.
Tell the date. Tell the
Petition.
date.
My lord, on 12/8/2022.
8/20.
22.
22.
You were on bail during trial?
No, man. From the very.
Look, this first one, it is to come after Durga Puja holidays. 4/50 of 2022. Hello. So far as this Asit Barik is concerned, take down that the learned counsel for the appellant submits that the appellant is in judicial custody since, please give the date,
12/8/22.
12/8/2022. And from the materials available on record, it would indicate that the appellant dealt a blow by dealt blows by wooden plank on the neck of the deceased during course of quarrel, and by picking of the same from the ground,
Which was lying.
which was lying on the ground, and picking of the same. The learned counsel submits that so far as eyewitnesses are concerned, PW5 only implicates the petitioner along with accused Subhas Barik to have assaulted the deceased on Agon?
Jharia Barik.
Deceased Jharia Barik.
JHARI.
Whereas the other two appellants, other two witnesses, eyewitnesses, that is PW 16 and 17, have stated about the assault made by the accused Subhas Barik. দুইজন জায়গা সুভাষ বারিক তো বলছেন না? And the postmortem report, which has been proved by PW18, the doctor, indicates that apart from the cut injuries and stab injuries, which are attributable to appellant Subhas Barik and alias Subhas, there are two lacerated injuries which were caused on the left parietal bone and frontal bone, but the skull was intact, and therefore, in view of the surrounding circumstances under which the petitioner stated to have caused the injury, cannot be said that a case under section 302 IPC is made out against him. And since there is no chance of early hearing of the appeal in the near future, the bail application may be favorably considered. Stop. Learned counsel for the state, on the other hand, placed the statements of the eyewitnesses, the doctor conducted post-mortem examination, and further submits that at the instance of which accused the weapons were recovered, at the instance of the present petitioner, so also the appellant Subhas Bari, the weapon of offenses of weapon of offenses were recovered, which have been proposed to by PW 7 and PW 8. ठीक है? Considering the submission made by the land council for the respective parties, nature of overtact attributed against the petitioner, his period of detention in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed. Yes.
Item 22, second item to convey.
Puta?
Second appeal to convey.
এটা কতগুলো দুর্গাপূজা করে
এই প্রিভিয়াসলি অর্ডার
আমি তো অসিতরে দেব
অসিদ্র করে
ওইটা এই বেল অর্ডারটা হলো অসিতর আচ্ছা 220 450 দিব দুর্গাপূজা করব আচ্ছা ঠিক তো হ্যাঁ চলো
May I please, ma'am?
Yes, Mr. Rao.
And last document 26 is 25 minutes. The custody certificate and the criminal record was called for.
Giving.
So, 841. 841 টা রেকর্ডটা বার করো।
That serial is as a case. 723. Huh? That's what plan.
So, two accused persons were facing trial.
Yes, ma'am.
And both of them were found guilty.
Yes, ma'am.
And they have preferred two separate appeals.
Yes, ma'am.
Other accused person has not participated in the crime.
But the convicted was 300 to allow other offense. But if he has been released on bail, serial number 841 of.
Just a minute. That
Sittu
Panda, he has been directed to be released on bail in by which order?
22/4/2025. Sittu Panda is the wife of the deceased. The present petitioner has a illicit relation with the Sittu Panda.
देखिए just for him appellant submitted appellant Sittu Panda is the widow of the deceased.
Yes.
She was on bail during trial, no direct evidence based on circumstantial evidence, and whatever circumstances are available, that is against the accused Vishwaranjan Gupta with the appellant in CRLN number 723 of 24. And petitioner has been implicated on suspicion, so and so. Acha, State Council submitted extramarital relationship, which is the motive behind the commission of the crime. In the call detailed report collected by the IO, also indicate that he had this contact with the co-affiliation. That is how, so your case is distinguishable. You are right that both of them have been found guilty under 302 by 24. But one of the consideration was that she was a lady.
Yes, yes, madam.
She was on bail during trial. It's not a case of direct evidence. All these things were considered, and she was so merely because the lady has been granted.
I'm not
bail-
saying, madam, I'm not saying that.
Then you saw
1 year's custody only.
you are in custody for just 1 year.
No, my lord, about 6 years, madam.
No, this was
About 6 years in custody.
ଆପଣଙ୍କର କଷ୍ଟଡି ତ ଦିଆହେଇଥିବ ନା
Vishwaranjan, na?
ବିଶ୍ୱରଞ୍ଜନ
It's a total sentence including remission is 1 year.
you arrested
No, this is report, 1 year.
ନାଇଁ ସେଟା ହଉଛି ଆର
Vishwaranjan.
ନାଇଁ ନାଇଁ ସେ ଆଉ ଗୋଟେ କୋଉ ଜେଲରେ ଥିବ ସେ ସେଠି ଏଇଟା କନଭିକ୍ସନ ପରେ ଜେଲକୁ ପଳେଇ ଯାଇଛି କାରଣ ଏଠି ଦେଖୁଛି ଜଜମେଣ୍ଟ କପିରେ ସେକେଣ୍ଡ ପେଜରେ
But this, then what kind of, full report you have to give, na?
ସେ ଆର କଷ୍ଟଡି ରିପୋର୍ଟ ଆପଣ ଦେଇନାହାନ୍ତି ମୋଷ୍ଟ ଲାଇକଲି after conviction he was taken to another jail. That is why it is the report of from 28/2024 ଯୋଉ ଦିନରୁ ସେ କନଭିକ୍ସନ ହେଲା ପରର ରିପୋର୍ଟ ଏଇ ଦିନ କନଭିକ୍ସନ ହେଇଗଲା 28 ତ ତା ପୂର୍ବର ଯୋଉ ରିପୋର୍ଟ ଯୋଉଟା ଟ୍ରାଏଲ କୋର୍ଟ ମଧ୍ୟ ଜଜମେଣ୍ଟରେ ରିଫ୍ଲେକ୍ଟ କରିଛନ୍ତି 2/11/2013 ରୁ ବେଲ ହେଲା ତାକୁ 14/8/2018
Plus this 1 year.
ପ୍ଲସ୍ ଦିସ୍ ୱାନ୍ ସେଟାକୁ ସେ ସେୟା କହୁଛନ୍ତି ଯେ ସେଟା ହଉଛି 4 year ନା ସେଟା ହଉଛି 4 years 9 months ଇଏ 1 year ତେଣୁ maximum 5 years
6 years 11 months.
6 years କେମିତି ହବ
এটা 4 years
4 year 9 months.
4 year 9 months, 1 month.
ବର୍ତ୍ତମାନ ଏଟା ବର୍ଷ ହେଇଗଲା 1 year ହେଇଗଲା 5 years and
4 5 ଆଉ 9 ମାସ ହେଲା 5 ବର୍ଷ
about 6 years
6 years
Vacation.
ଆଉ ଏଟା ଭ୍ୟାକେସନ ପଡୁଛି
complete evidence ନାହିଁ ଖାଲି ଟୋଟାଲ recovered
after Durga Puja holiday look
during time also you are done with the same evidence madam.
Yes,
It's the 27 recovery but except there is no other material madam.
ଆପଣ ଦି ଜଣ ଯାକ ଟିକେ ଅଲଗା ଅଲଗା ରହିବା ବର୍ତ୍ତମାନ ଦରକାର ବୁଝିଲେ ସେଇ ଗଣ୍ଡଗୋଳ ପାଇଁ ଗୋଟେ ମର୍ଡର ହେଇଗଲା yes next
Item 23.
After vacation
yeah
My lords, I had filed an IA for interim bail minutes and to withdraw the application. My lords.
କୋଉଥିରେ କହିଲେ ଆଚ୍ଛା ଏଇଠାରେ ଲର୍ନିଂ କାଉନସିଲ ଫର ଦି ଷ୍ଟେଟ୍ ହାଜ ଫାଇଲ୍ଡ ଦି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ as well as ଆଉ ଗୋଟେ କଣ ଫାଇଲ୍ କରିଛନ୍ତି criminal antecedent which are taken on that one. Yes, the item number 23 କଣ କହିବାକୁ ଚାହୁଁଛନ୍ତି
Permitted to withdraw the IA minutes.
IA for interim
My
bail
lords.
IA number 1193 of 2025 this is an application for interim bail. The land council for the memo file କରୁଛନ୍ତି ନା ଏମିତି submission the land council for the appellant files a memo. Do not press this interim application. Memo is taken on the record on the IA is disposed of as not pressed. Yeah.
Item 24.
May I please, Your Lordship? I am appealing to virtual mode, Your Lordship. In the present case, there are two appellants, Your Lordship, and along with 149 IPC, Your Lordship, and sentenced for RI to undergo RI for 2 years and life, Your Lordship.
Madam, you have not supplied the deposition copies. That is the submission of the state council.
Just now supplied.
Ajay, just now you supplied. So let him go through it. We'll take up on some other days. Look on the land council for the appellant supplied the deposition copies to the land council for the state in court who seek some time to go through this and put up this matter in the week commencing from 28th July 2025. Yes.
Yes.
25.
My lord, prayer for bail, IA number 119/2025. Offense committed not.
Letter was issued, but regarding genuineness of that, the document had not come. Recently, the petitioner was on interim bail.
So now he is applying for bail on the ground of ailment of the mother.
Mother.
And medical documents have been annexed. So you are to take instruction about the authenticity of those documents. Health conditions.
Issued, but the instruction not received by the.
Okay. IA number 119 of 2025.
ଆକ୍ୟୁଜ ର ଘର ହଉଛି ମାନେ ମାନେ ଗଞ୍ଜାମ ମାନେ ବହୁତ 8 କିଲୋମିଟର ସହର ଠାରୁ ସେ ସେଇଥିପାଇଁ ତା ଶ୍ୱଶୁର ଘରେ ଯୋଉ ତା ସ୍ତ୍ରୀ ଅଛି ବରଣ ସାହୁ ୱାଇଫ ମାମିନା ସାହୁ ତା ଘରକୁ ଯାଇକିରି ତାର ଗୋଟେ ମାଇନର ଛୋଟ ପିଲା ଅଛି ତା ଘରକୁ ଯାଇଥିଲେ ସିଏ କୋଉଠୁ ଆଣିବ ବୁଢୀ ଯାଇକି ଅଛି 80 କିଲୋମିଟର ଦୂରରେ
କଣ ଆମେ କହିଲୁ ଆପଣ ତ ସିଏ ଆପଣ ଦେଇଛନ୍ତି ତାର ୟାର ଯୋଉ
15 ଦିନ ପର୍ଯ୍ୟନ୍ତ ସେ ଚେକିଂ ହଉଛି ସେ ମାନେ କେହି ନାହାନ୍ତି ତାର ନେଗୋବର
ସେଟା ପୁରା ସେ ଭେରିଫାଇ କରି କହିବେ ଷ୍ଟେଟ କାଉନସିଲ କହିଛି
ଜେନ୍ୟୁନ୍ କେସ୍ ନା
I am not disputing that. It is
ଆଣନ୍ତୁ ଟିକେ ରିପୋର୍ଟ ଆଣନ୍ତୁ ଆପଣ ହେଇଥିବ
old age lady lumbar
ଯାହା ବି ହଉ ଆପଣ ରିପୋର୍ଟ ଆଣନ୍ତୁ ଆଉ ମାଙ୍କ ଦେହ ଖରାପ ସେ ଯାଇକି ବୁଲିକିନା ଆସିବେ ଦେଖିନି ଚିକିତ୍ସା କରି ଆଉ କିଏ ଘରେ ଅଛନ୍ତି କି ନାହିଁ ତାଙ୍କ ମାଙ୍କୁ ନେଇକି ଯିବାକୁ ଏ ବିଷୟରେ ମଧ୍ୟ ଆସର୍ଟେନ୍ କରନ୍ତୁ ଆଣନ୍ତୁ ରିପୋର୍ଟଟା ହେଲା ଆଉ ଏଇଟା ତ ଗୋଟେ ୟାର ନା ଏମକେସିଜି ମେଡିକାଲ କଲେଜର ହେଲା
ପିରିୟଡ ବସି 3 years 5 months ହେଲା
ଦେଖନ୍ତୁ the Land and Council for the state seeks some time, further time to obtain instruction as for order dated 20/6/2025. Put of this matter next week रखियो कारण already नहीं करेंगे
माइनर तार मदर इज सीरियस कंडीशन अरे मोरी मार जो नहीं लाभ कौन से नहीं कौन से ना कहीं ना हाँ से बहु पड़े ऐसी बार कहीं ना
yes next
26
Please, but I am praying for the
mention is made you are Mohini Sahu Land Council appearing for the appellant 6 for an adjournment for yes
item 27
May I please rush? That's it. Last occasion, verifying the statement of the appellant, direction to me, Lordship, that is verify the disease of psychosis and Lordship. Lordship, psychosis and patient is suffering from psychosis and Lordship. Last occasion, received the information from the state Lordship that the health condition of the appellant Lordship.
No, you have filed for interim bail or what?
No, Lordship, I am filed bail.
The petitioner, he want to take on custody of the present appellant. Appellant is a psychosis patient.
That's just right. The father is 77 years. He can't take care of her.
That was the reason why we asked her. कौन आसिला आपनो?
That is reflecting 14/5/2000.
14/5/2015-25 रे हमें करथिलु Land Council for the state has produced the written instructions from IIC which indicate that the father of the appellant is 77 years and mother of the appellant is dead. Though the father has stated that he can handle the appellant and keep him under proper medication as well as supervision if he is released on bail, in view of the age he might not be able to handle the appellant who is suffering from psychosis NOS, and it would not be ruled out that he may be a threat to the society. That was the report furnished.
In this case, I am taking instruction from the superintendent of the jailer, that is Abanti Singh. She stated that his behavior is good, Lordship.
वर्तमान ताकू जेल ले समस्त प्रकार सुविधा जोगे दिया जाउची ताकू नै किनी गवर्नमेंट हॉस्पिटल ले ट्रीटमेंट कराउची ताकू औषध दिया जाउची रेगुलर समय रे सेथि पई तारो ठीक ठाक अछि बट ये जो टाइप रो पेशेंट ता घरे ता मां नाही बापार बयस होची 77 वर्ष जदि से मेडिसिन डिस्कंटिन्यू हे गला बा कौन है ये आउ गोटे प्रकार कौन क्राइम करदब तेणु से समाने रिपोर्ट देइथिले जे बापार बयस जेहेतु 77 वर्ष कि जदियो सी कहूँ मु हैंडल करदेवी बट इट मे नॉट बी पॉसिबल दैट इज द प्रॉब्लम नाउ
Lordship, kindly grant interim bail, Lordship. If observe that
कौन जाई करियो सेटु
is not safe for your father also. Because he's 77 years. You are a psycho patient. You may attack your father.
So many things can happen because he will not be there always and confine the son. And,
Without any reason, killed a lady, my lord, an old lady.
Old lady. There is
Paralysis
no.
patient.
If there would have been someone else in the house, one can think of. A man of 77 years.
77 वर्ष वर्तमान ट्रीटमेंट चलची इशू
Not safe.
That is marvelous की the paralysis lady bedridden ताकि ताकि कोई किसी की आउट रूम में अच्छी असला करते पर.
But that is the case of the
Lordship,
without-
nobody can see in the case.
that is to be considered on merit, but the prosecution case is that you have killed a lady with a paralysis patient and no motive also.
Yes,
So that was the because you are suffering from this type of ailment, so there is the risk that you may be a threat to the society, and that is how we obtain that report. So barely gale ei problem hei pare tonu seit pai
How many years you are there in the custody?
Lordship, custody since 19/7/2021.
21. Okay.
বর্তমান চিকিৎসা তার চলছে
Best place for
Better for you to be there in the. You get proper treatment.
Once they were taken from the jail for treatment, that obviously that priority is given and they are able to show the doctors. But once even nobody knows that whether he will be taken to the hospital or not. He himself.
Financial implications so should be covered.
There are 1,000 pending
After vacation.
after Durga Puja vacation. Yeah.
Once you will stable, then we'll see. Yes.
Item 28.
Actually, 295. Why it was adjourned to today?
To obtain instruction.
What is the
That is the conduct of the petitioner during trial. He was on bail.
Oh, I see.
Conduct
During trial, during
trial, the present petitioner was on bail. And another, what is the present status of Banki PS case number 251? The set apart, what is the status of Banki PS case number 446?
कौन लिखी जानी कौन आईने इंस्ट्रक्शन या नाटा कौन हला भक्ति कृष्ण स्वाइन
आया
अपन लिखिले
सेक्टर 251 रे for appearance.
So just a minute, को लाइन टा मन कौन दे
मतलब first paragraph.
हाँ.
That on the written report of complainant Sunita Patua, Banki PS case number 251/2020 under section so and so. Registered in last line, the case is pending trial in the court of SGM Banki. Date has been fixed to 24/7/2025 for appearance of accused person in the honorable court.
Okay.
Next, another FIR was lodged by where the
some of the henchmen of the present appellant
At the
pretend to be.
henchman of the.
What is the allegation? On that case, the case is now under investigation and for apprehension of the accused person.
No, in that case, petitioner is not arraigned as an accused. One Sumitra Behra lost the report. Okay, now then what you have
Then, my lord, that said Gati Krishna Swai is an influential political leader in the locality having some bad reputation in the area. He is in habit of convening meeting with some antisocial person and insisting them to indulge themselves in antisocial activities. During his presence in village, innocent people are apprehending panic situation. The conduct of appellant while he was on bail from 24/12/2020 to 7/11/2024 was not good. That locally and confidentially it is learned that the supporter of Gati Krishna are creating havoc in the locality and also threatening the family members of deceased and the prosecution witness in different ways, for which innocent people and family member of the deceased are not daring to lodge any complaint against them at case. So there is apprehension and threats to the family member of deceased, also prosecution witnesses.
Not a single case after 23/12/2020 for violation of any condition or threat to any.
That's what they say, that no,
And
nobody
I have-
daring to register any case
Well,
against.
that everybody can say, because I am a political person. That is why the party is not in power, the opposition is in power. That is why I am a threat.
No, we are not entering into that, but.
That is the instruction.
No, that is the
Political
report
person.
which whether power or not. So.
Because an influential political person, जिला परिषद member ଥିଲା ଆଉ election ଲଢିଛି ହୁଅନ୍ତାନି. For that reason he might have been implicated. God knows.
Conditions can impose also.
Lordship can impose any stringent condition also.
Very suspicious now. You just take it properties. We know the reason now.
That is why I want that it should be hard and disposed of. And what sort of an apprehension is this? Anybody can, I might be a threat to society. Corner political volatile situation. As normal as anything else.
Okay, yes. After the.
Civil putting it up.
2 weeks.
2 weeks for it.
2 weeks.
Yes, next.
Item 29. Vikram Vadai. The report.
On two aspects,
Petitioner report was directed the State Council to obtain report. One is the
Criminal
period of
antecedent,
detention,
yes.
other is the criminal antecedent.
Bahana Behra.
I am in that case, my lord. I am appearing for Banbir.
ହଁ ସେ ଗୋଟେ ଗୋଟେ ଦଉଛନ୍ତି ପୁରା
There are 3 cases, huh? 3 appeals.
that is for Bahana Behra. Just Bahana Behra. No, about the first period of detention, 7 years, 4 months, 30 days.
Antecedent.
And antecedent?
Nine. As seen, but he have the antecedent, I can produce. I have that copy. I am appearing on behalf of the Bahana Behra. Nine. He has been involved in a case of 436. He has assaulted to the video. Many cases.
State
My
court
friend
State court
says that was available, that was produced on the earlier date. That is part of the file for us.
About antecedent of Bahana Behra.
So,
Subject to verification.
Mr.
Yes, last showcase
Bahana Behra na.
Sahoo Hon'Ble.
Bahana Behra na ଏତେ ଗୁଡା କେସ୍ ଅଛି ନାଇଁ କଣ କହୁଛନ୍ତି ଏଇଟା କିଏ ଦେଲା ତା
There is a report.
Report at the
Already
he has committed
of IIC Pikli Police Station
7 cases.
has given a report to the Advocate General Office and it has come to this file.
26/5/25.
ଏଇ ତାଙ୍କୁ ଗୋଟେ କପି ଦେବୁ ଏଇଟା ବାହାର କରିବି ତ ବାରମ୍ବାର କହୁଛି ଆପଣ ଗୋଟେ କପି ରଖିକି ଦେବେ ଏଟା ଗୋଟେ ଭାଇଟାଲ ଇନଫର୍ମେସନ ଆପଣ ମନା କରିଦେବେ ସେଇ ପେଜଟା ଦିଟା ପେଜ ବାହାର କରିଦେବି ଆଜି ସମସ୍ତଙ୍କର ଲେଖା ହେଇଛି ନା
Antecedent of all the accused. Sahoo Hon'Ble.
ନାଇଁ ଆଜିରେ ଇଏର ବି ଅଛି ସେ ଯୋଉ ବେହେରାର ବାହାନ ବେହେରାର ବି ଅଛି say that I have not received but in fact they have received that is there ଦେଇଛନ୍ତି এটা দেখুন মিস্টার
Yes,
so what do you say about 7 cases are there
Let
against
it lie over come after vacation, my lord. Super bail is
the Learning Council criminal appeal number 177 of 25 the Learning Council for the state has produced the custody certificate which is taken on record. Stop. Earlier the Learning Council for the petitioner has submitted the report relating to the criminal antecedents against the petitioner. Stop. From the said report dated 26/5/2025 of IIC Pikli Police Station, it appears that there are as many as 7 criminal antecedents against the petitioner. Let the Learning Council for the petitioner obtain instruction relating to the status of those cases. File a comprehensive affidavit relating to the status of such cases. Put up this matter as prayed for. Put up this matter after ensuing Durga Puja holidays. Mr. Aniruddha Das, Land Council for the informant is present. So it has this Yes, Mr. Mahapatra, what is your case?
And Lord, your lordship may first see the criminal accidents in respect of the 5 petitioners for whom I am appearing.
In this Dharmananda Behera, upon
Yes,
Pasta Chandi.
I
The criminal appeal memo ta dekhilu. No, Dharmananda Behera. 224. 1, 2, 3, 4, right. 5 জন আছে।
224
ହଁ ସେଟା 5 ଜଣ ଅଛନ୍ତି।
ତା ଦେହରେ ସେ 5 ଜଣ ଭିତରୁ ଜଣଙ୍କର ଗୋଟେ କ୍ରିମିନାଲ ଆକ୍ସିଡେଣ୍ଟ ହେଇଛି 506 one of the appellant ଆଉ ଅନ୍ୟମାନଙ୍କର ସେ ଯୋଉ କେସ୍ ଲେଖିଛନ୍ତି ଏଇ କେସ୍ ଟାକୁ ଲେଖି ଦେଇଛନ୍ତି
175. Equally 175 is the present case.
So no other case.
But Paramanand Behra has one more case. That is PPLPS case 12.
506, my lord. That was in the year 2015.
Okay. Then what is the accusation against this?
Total accusation against him, they were present at the time of specific allegation was made against the persons who were armed.
How many persons died?
One.
What is the name of the deceased?
Bablu alias Chinmay Sahu.
Bablu alias Chinmay Sahu.
My lord.
What is the date of occurrence?
28/5/2017.
ଏମାନଙ୍କର custody certificate ପଳେଇ ଆସିଲା ଏମାନଙ୍କର custody certificate
28/5/20
ଆସି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଅଛି
28/5
ହଁ ଅଛି 2017 ମେରେ ତମେ ରେକର୍ଡ ରଖୁନ
28/5 କେତେ
2017
ଆଚ୍ଛା ଏଇ ଯୋଉ ଆଫେଲାନ୍ସ ମାନଙ୍କର କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ
ଅଛି ଆସିଛି ଦିଆହେଇଛି ରେକର୍ଡ
ଅଛି ଆପଣଙ୍କର କପି ଅଛି ମିଷ୍ଟର ମହାପାତ୍ର
ଆଜ୍ଞା
ଦେଲେ
କଷ୍ଟଡି
Mr. Naik, we have passed an order that you convict ମାନେ ସବୁ ରହିଛନ୍ତି ବିଭିନ୍ନ ଜେଲରେ ଯୋଉ ଆପଣ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ପାଇଁ ଡିଲେ ହଉଛି ସେ ଡାଇରେକ୍ସନ ନେଇଛି ଟୁ ଦି ଡିଜି ଅଫ ପ୍ରେଜେନ୍ସ ଦ୍ୟାଟ୍ ସମସ୍ତଙ୍କର ଯୋଉ କଷ୍ଟଡି ଇଏଟା ସାର୍ଟିଫିକେଟ ଦ୍ୟାଟ୍ ମେ ବି ଏ ୱେବସାଇଟ୍ ମେ ବି କ୍ରିଏଟେଡ and it may be uploaded ଆଉ time to time ସେଟାକୁ ଆପଣ ଇଏ ଅପଡେଟ କରିବେ ତାହେଲେ ଆମେ ବି ଏଇଠୁ ବାହାର କରିପାରିବୁ ଆପଣ ଯୋଉ ଟାଇମ ଆଡଜର୍ନମେଣ୍ଟ ସେମାନେ ବି ଯେକୌଣସି କନଭିକ୍ଟ ଚାହିଁଲେ ପ୍ରତ୍ୟେକ ଜେଲରେ ଏଇ ନା ଇଏ ସେଟା ଡିଟେଲ ହଉଛି ଦେଇଦେଲେ so that order we have passed please bring it to the notice we have asked the registry to send it to the DG of prisons because he is the best person that we will do but from your side also ask the London Advocate General to pursue that so that it can come immediately ଏଇ ଯୋଉ ସବୁ କେସ ରେ ଆପଣ ଦେଖୁଛନ୍ତି ତ ଏଇ ଯୋଉ ଡିଲେଟା ହଉଛି ଆଉ
half of your work will be
yes Mr. Mahapatra
I will place one point before my
ଆମେ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଆଇଲି
କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଅଛି
ମାନେ 10 ସାର୍ଟିଫିକେଟ ଚିଠି କରିଛୁ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ପାଇଁ
ନାଇଁ see Mr. Mahapatra made a submission that it is available on record
just I am submitting so far the 5 persons are concerned they were on bail during course of trial why they were released on bail I will explain there are 4 eyewitness to the occurrence
Mr. Mahapatra we just want that what is the period ମାନେ ट्रायल बेले आउ याकू मिसेइगिनी वर्तमान टोटल केते रहले
पिरियड टा कहि देबे जे कि मोर पाखे
ऑथेंटिक कॉपी नै सेति पई let it be taken up next week you tell us date when
yes sir
माने आपन केबे अवेलेबल थिबे कोनांती
नेक्स्ट वीक एनी
बुधवार
कमिंग वीक आई एम
मिस्टर अच्छा लेखन आइटम नंबर जोटा CRLA नंबर 224 of 2025 the London Council for the State submits that he has already sent intimation to the jail authority to obtain the custody certificate in respect of all the 5 appellants and the instruction is still awaited and the matter may be taken up next week. Release this matter on 23rd July 2025.
My lord, before parting, may I say one thing?
Yes.
My friends may examine. Actually, what happened once the 5 persons to whom I am appearing, they were before this on court for bail. At that time, a observation was made that after the examination of the eyewitnesses, their bail application will be considered. And basing on the evidence of the 4 eyewitnesses, my lord was pleased to release them on bail on the ground that they have not assaulted the deceased, simply they were present. So they may examine that.
That order is available with you.
Yes, yes.
Please hand over a copy also to that, because
That was during trial.
That was during trial. But after perusal of the evidence.
Evidence of PW 1 to 4.
Okay, just give it. Ajalekham. The Mr. Mahapatra and counsel senior advocate handed over the copy of the bail order of this court in respect of the 5 appellants, which was granted after the
Perusing the evidence of the
eyewitnesses. No? So it will come on 28/5/2017 with that CRLN number 497 of 2025. Arata to assume dosara. So that Baki rest of the matter will come on Friday.